just one of those old guys that happens to think that we need two parents in our lives. I think it's hard enough with two parents. So if one parent is shirking their obligations and responsibilities and not doing what they're supposed to do, there ain't no way, no how, nobody is going, I don't care who they are, that's going to convince me that that child or children are not affected. I don't care who it is. That no fighters. Musso. Daniel Christopher Musso, 26W8422220. I'd like the victim up here, Desiree Musso, please.
Morning, Your Honor, Mike Clark, representing Mr. Musso, Association of the record.
Daniel Christopher Musso.
All right, your name, please. Your name, please.
Desiree Musso.
All right, so defendant pled here to telephone harassment under section 771.1, and he was referred for a pre-sentence. Actually, he pled, I believe the plea was no contest. So I did say I would take it under 771.1. It says ongoing family court in the bottom of the stipulation, defendant in therapy, therapist present today. Is the therapist, your therapist present today?
Not today.
Not today, it's Friday.
All right, so let's figure out what everybody's going to say here and do here. What do you have to say, Mr. Crawford? Did you review this report with your client? And are there any material additions, corrections, or deletions?
We have a review with my client, Your Honor. We had no material issues or deletions, Your Honor. He believes he can comply. Moving forward, Your Honor, we would ask that the court adopt this recommendation as presented.
Sir, is there anything you would like to say?
Just that I'm very sorry for harassing.
Okay. All right. Ms. Musso, what would, I want you to take your time. I could tell you're a little upset. Just I want you to take a deep breath, and I want to listen to anything that you want to say to me, okay?
The mental, physical, emotional, psychological abuse that me and my children have experienced at the hands of this man is nothing short of heinous. My kids are scared to go to school, stand at the bus stop, they're looking out the window all night long. We have experienced heinous abuse since I was a teenager, and this man was nearly 40 at the time. He has gaslit me, manipulated me, broken me down mentally, physically abused me, completely ruined my life. I single-handedly raised our kids with no child support. I am not on Medicaid. I am not on SSI. I am not on all these false allegations that he claims. I have single-handedly raised these kids myself. He never submitted his court-ordered drug tests to implement his parenting time. He never complied with all.
So you're talking about in the circuit court, right?
Okay, I'm sorry, I'll get to the point.
Don't take your time. I just want to make sure I'm understanding.
Yeah, so he never did what he was supposed to the entire time. My kids are grown now, and my son is in high school. He's never protected or provided for this family. They're both medically fragile. And he's purposely hindered them from being on Medicaid. He's purposely hindered them from being on SSI. I have taken every hit from this man and I've never retaliated. I endured so much mental, physical, and emotional abuse. He has completely broken me down. He has attacked me, my family, my race, my sexual orientation, my partner. He has asked if we're still alive. He is creating so much fear within my children that they don't even want to stand at the bus stop. He's never been a part of their life. He's never been to the school. He has never taken them to a doctor's appointment. My son had cancer, Your Honor. He went to jail multiple times during his bone marrow transplant. Okay? He has been estranged from our family for years, and I periodically allowed him to see the kids at Christmas and different holidays where I thought he might not be high and that my kids might be okay enough to see him for his little couple of parenting hours, but he had become so heinous. He has escalated this violence to the point where I can hardly stand here and testify. I'm holding myself up with this wall, and I'm trying to be strong. for my kids. But when my kids can't stand at the bus stop and they're too scared to go to their soccer game and they're too scared to go to their karate because he might be standing outside of it, he was warned multiple times that this was going to be harassment. Detective Remy went to his house and warned him. Okay? He still decided to do this after that warning. Once he was criminally charged, he still continued to harass me, stalk me, intimidate me. I took a picture of this man outside my son's karate, which my son won't even go back to anymore. I made another report in Trenton, but we didn't go through with those because we didn't want to add on to this. He is heinous. He's evil. I'm in church. He's sending me satanic messages, words that I can't even repeat in court. 40 back-to-back messages, none of which were child-focused. He's leaving me voicemails to the point where when my phone rings, my kids jump out of their seat. They're terrified of him. I'm terrified of him. And I'm going to sit there for 2.5 hours with this man. And just of control, this abuse and domestic violence is going to end today. I can't be for my kids because you might be able to treat me like that, but these boys didn't need to endure this. And they heard those messages, they heard those voicemails. They went into my sleeping at night, they said, we couldn't see what Dad said. They're staring out the window all night long. I'm having to pick up from school early because of pain stomachs. These are straight A kids. These are medical professionals. They're terrified of you. And any part of a relationship that you thought you could possibly restore within these children, you tried to destabilize the very foundation I've set forth for them. I've never asked you for a dime, Dad. I've never asked you to show up or do anything that a father would protect or provide for an individual, and you have berated me. Within the community, I'm embarrassed to even be here. I know some of the people in this courtroom right now. This is embarrassing. Your children deserve better. You have abused me since I was a teenage girl. You've manipulated me, gaslit me. You have physically abused me, and I've never recorded half of it. You've thrown me down the stairs, and the way you treated me when I was pregnant is heinous. And I'm sorry that I'm this upset, and I tried to maintain my composure, but the things I endured, and in those messages, I never once said anything ill back to him. I never once said all the things in my heart that I wanted to say, and my children said, Mom, please go to the police. Please go to the police, he might kill you, and then who's gonna take care of us? And that's why I'm here, because if he does something to me, who is going to take care of my son who had cancer and is getting all these infusions and medications? This man has tried to manufacture evidence that doesn't exist in the last couple of months by trying to provoke me via text message to portray me in a negative light for family court. His evidence doesn't exist, and the truth always comes to light. He has tried to provoke me by attacking my family, my kids, everything, just to get a reaction out of me. He has been to jail. He has done probation. He's been to inpatient. He's been to outpatient rehab. Nothing is stopping him. Every punishment has been proven to be ineffective. He's been to jail for everything. Sermons? I mean, what is going to change him? He's almost 60 years old. I'm almost 40 years old. I'm standing here shaking. I'm embarrassed for myself. I'm embarrassed for him. And I don't hate him the way that he thinks. He hates me more than he loves his children. And I'm standing here because the Lord Jesus Christ sustains me.
Anything else?
Untrue.
Anything else?
Nothing but to emphasize that clearly this is a matter that needs to be worked out in family court. Whatever allegations she stated, they're very troubling. My client is troubled by them. but he can't speak. We don't speak to the veracity of it, but now he's taking responsibility. He said he's sorry for the poor behavior. This is the subject of this case. And Your Honor thinks that this recommendation is appropriate for the evidence that prosecution set forth in this matter. And he'd just like the opportunity to move forward and proceed with this case in family court and get this worked out the way that court believes it should be.
As it stands, as I understand the order, he has to drug test in order to see the children.
We did one and he never submitted anything else. He's supposed to also pay half of all my children's medical bills. He never did.
Okay, I don't want to talk about that payment yet. I want to make sure the judge's order you're telling me says,
The part of the parenting plan says in order for him to see the children, he has to complete X, Y, Z, and it's gotta be supervised and all of this stuff. This isn't a family court issue. This is domestic violence. This is criminal court.
no, I know, but I just want to make sure there's nothing I can do here, and it doesn't sound like there is. The circuit court, well,
Children, anything to keep them away
but
from.
the circuit court doesn't have that order in effect, though, do they? I can't start sticking my nose in children's issues. This was
Maximum punishment and that you deal with him aggressively because there's been no punishment in the past that has been proven effective at this point. He's been in rehab, he's been to jail, he's been in and out of rehab.
let me ask you a question. I'm not seeing any conviction for any reason since 2000.
He in Wyandotte,
Is that true or false?
Walking into his neighbor's houses naked and high on drugs. He went to jail twice while my son was inpatient at Children's Hospital for whatever substance related abuse charges that he was doing. I couldn't tell you the exact charges, but that is true and that is, provable through a FOIA if you requested that.
See, all that should be on his criminal history, and all I'm telling you is I'm seeing a 1992 operating while
No,
intoxicated.
sir.
I'm seeing a 96 ordinance violation of some kind out of this court. Maybe you can check that, Heather. And then hang on one second. And then a 2000 unlawful bodily alcohol content, they used to call it, operating while intoxicated, again out of this court. But I'm not seeing one thing in here subsequent to that.
It would have been probably around somewhere between 2011 and 2014 or 15, somewhere in that time when my son was sick. He did go to jail twice in Wyandotte. Went to jail twice. My dad went and got him. We paid the bond. At that point, we were still married. So
Is that true? Did you go to jail in Wyandotte twice?
I don't recall, Your Honor.
And Your Honor, I mean, even if he was, Your Honor, I mean, it's innocent to proven guilty, no charges came up.
Well, wait a minute, slow down. Hang on. Yeah. Sometimes if it's a 90-day misdemeanor, these might not make their way onto his criminal history. That's all I'm pointing out.
Sure.
And they're not on his criminal history. So that means one of two things. The judge, if it was less than a 93-day misdemeanor, the judge may not have ordered printing and photographing. If they did, then it would have entered up on his criminal history if there was a conviction. If they didn't, then we don't know enough to be able to say.
Your Honor, to the extent that there's anything to these allegations, I point out the time period you're talking about is 2014.
I get
12 years ago.
I get it.
in 2015, he went to inpatient rehab in Oakdale Rehab. That was 2015. My second son was 3 months old at the time, and my other son was going through bone marrow transplant treatment.
Your Honor, my client will not deny that he's had trouble with drugs in the past. He's got certain serious mental health issues that he's
I get it.
help with now.
I get all this.
Doesn't allow me.
I get all this, but you have to understand something, both of you. I cannot sentence somebody, ma'am. I cannot, in good conscience, sentence anybody on things that are allegations that were not proven. Please listen to me. You said you wanted me to give him the maximum. There is no way I can give him 90 days based on what I've heard here and based on, I just want you to understand. And the convictions, if any, are not part of his record. So if there was a conviction since 2000 at any court, in any place, it would be reflected on his criminal history. Please listen. So I want you to understand that there's an element of fairness to this process. It's most important, and that is that there has to be fairness, right? On the other hand, too, sir, you have problems. I mean, what did I read? You sent a picture of a dead mouse to her and said, "This is you," or something like that.
I've noticed this.
Listen, well, this is what the officer said. I mean, this is what the officer said. You are a piece of S, you effing C. Calling WPD welfare check, something bad I don't even want to repeat in here. She's asking you to stop in May of 24. You sent a photo of a dead mouse in a trap with a follow-up text, "Gotcha." If you spend half the time, it seems to me, trying to get yourself some help and trying to do something productive and trying to make your relationship with your children better, you wouldn't be here and your life would be a lot better. Now, I understand. I heard her. I hear you. But to me, some of the things I'm reading here are disturbing. And I'm not going to go back. I want you to understand something. I'm not going to consider anything other than your record of what has happened here because it's not been proven in the court of law. That's the good news. The bad news is that if I find out you're contacting her in any way, in violation of my order, I'm going to give you the maximum. You still can go get a PPO if you choose to. You might want to consult with a lawyer about what process to take. But sir, you seem out of control to me. You definitely seem out of control to me. You might not think so. I bet that you don't think so. It's okay. I just don't know why you would be acting like this. You have children. They are the single most important thing. They should be in your life. More important than you or your hatred of her or anything else you're doing. They should be more important to you than anything else in your life. And here you are, you're not seeing them because you're not drug testing in violation of a judge's order, it sounds like. And that's a whole different issue. You want to go your whole life, not know your kids, continue on this journey. Simple. It really is simple. And I'm just one of those old guys that happens to think that we need two parents in our lives. I think it's hard enough with two parents. So if one parent is shirking their obligations and responsibilities and not doing what they're supposed to do, there ain't no way, no how, nobody is going, I don't care who they are, that's going to convince me that that child or children are not affected. I don't care who it is. I don't care how much money the other spouse has that's raising them. I don't care who it is. That's if you don't want your kids to turn out, keep doing some of the things you're doing. Now, probably just talking and it's going to go in one ear and out the other. Your children, not mine. I think that's where we've gone wrong. People don't think about that anymore. Right? I yearn for the days of Ozzie and Harriet. leave it to Beaver. 18 months probation, I'm only gonna charge you like it's 12 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. I really have no basis to believe that it was used, and I don't order that in this case, but there's enough here where I'm ordering it, but I'm not gonna order. I'm gonna order you to submit to chemical testing, PBTs and ETGs on demand of probation. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to continue your treatment at the guidance center. You're not to have any contact with Desiree Musso. You're not to possess firearms. When I say no contact, I mean you're not gonna write her, phone her, see her, text her, email her. You're not gonna do any of those things. When you comply with the orders of the circuit court to see your children, then you're gonna go back to that order. And I'm gonna say here specifically, unless and in contact, unless, so no contact with her, unless in conflict with order of Wayne County Circuit Court. So I'm just telling you, the order would permit you to, then I'm gonna allow it. But otherwise, if you're just playing games with her and harassing her and threatening her and saying these nasty things, you're gonna go to jail for 90 days. You're not to possess firearms. You're not to possess dangerous weapons. You are to serve 100 hours of community service. 100 hours of community service, and I'm gonna give you until September the 1st to complete that. I'll actually make it September 30. We're going to have review hearings in this case. Again, you're going to continue your treatment at the guidance center. I'm going to go light on the fines because I don't think you have any money. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4. Probation fees are $240 because I'm reducing those to from $360. So your total's $565 plus the screening fee of $60 for $625. And we are going to set review hearings every 3 months, Heather, on Woodhaven dockets. Review hearings to be set every 3 months. I want you to go down the hall. We are going to give you a notice. If you think you're prepared to give me those dates now, Heather, you can. I'm going to have you take your time though. I'm going to have you pay $75 per month. I'll start that beginning on July the 15th and the 15th of every month thereafter. Now I'm cautioning you. Like find out your contacting her. Unless otherwise permitted in accordance with that order, the Wayne County Circuit Court for that sole limited purpose, because I don't have the order in front of me. You're gonna go to jail for 90 days. Do we understand one another?
Understood.
You have 21 days to appeal this order, 14 days to apply for a court-appointed lawyer for purposes of appeal. Review hearings to be set every 3 months. If you need time, Heather, I'll be glad to give you all the time you need.
We
I
could,
don't even, go
we
ahead.
could probably do them. I
Go
could
ahead.
probably count them out. Well, the first one will be September.
Okay, September what?
We'll do September 16th.
At 8:30 in the morning, and you're welcome to come. And you tell me if he's violated the order in any aspects, and if there's any different violation that occurs in violation of these orders, you're gonna call up and speak with the probation department and or the police department from Woodhaven. September 16th at 8:30. I'm not gonna order this impulse control program. I just want you to continue your treatment at the guidance center. We understand one another.
Understood.
Okay, when's the next one? December what?
December 23rd.
At 8:30 in the morning. And if you give me one more, that'll be good enough for now. So that'd be like
That'll be
March.
March. And then we'll do March. Let me see. If we're doing the 23rd, then that'll be, just gotta count out what. It'll be Brownstown. Woodhaven, Brownstown. We'll do March 17th.
At 8:30. Those are your 3 review hearing dates. We're gonna give you those. You're gonna meet with probation. Do we understand one another? You understand you're out of control, right?
Understand.
Do you understand that?
Yes,
No more.
I will.
Don't do it. I'm telling you, I will not be anywhere near this time. Good luck. Thank you. Thank you. Now let's take Seiler first. Alexis Rachel Leanne Seiler, 2678406188 and R. Somebody wrote down on here being discharged today. Are you Ms. Seiler?
Yes, I can.
Your name?
Alexis Virtual Being.
Did you talk to Mr. Crawford yet?
Yes,
Oh, sorry.
he was supposed to.
Come in.
All right, let's take these. All right, so I had Alexis, Rachel, Lean, and Seiler, 260-8406, 18A and R. Okay, your name again?
Alexis Virtual Being silent.
Like their property in the silent.
She pled the public nuisance on April 29 to 26, which was a civil infraction plea, reduced from the resist and obstruct, and then the operating with the impaired due to the consumption of drugs. She pled to that day. I ordered the screening and assessment. We adjourned it a week. So she was an inpatient.
Correct. Sacred Heart and Clarity.
Oh, and Beth, see if she's got proof of that, will you, please? Yes,
Is that the
just wait one.
probation officer lady?
Yes,
Yes, I talked to her.
oh boy. Let's go here.
And Judge, I'm pretty sure that Miss Wilds does have the proof because she did communicate with me about Miss Seiler also.
You know where Ms. Wilds is right now?
That I do not. Let me peek over and see if by chance she might be in Judge Hessen's, but no, I do not see her in there either.
Judge needs something bad. You're on silent. She's not answering. Thanks.
Did you have a chance to review this report with her?
I had the opportunity to report,
Are there any material? Good.
there are no request for material revisions or deletions, Your Honor. My client believes that she can comply with these recommendations, Your Honor. Her only issue might have to do with those that require money, Your Honor, because she's away getting this treatment.
You don't look that good. Is something wrong?
Huh?
Is something wrong?
I can't sit still. I detoxed off of Suboxone and I just got back on it. I went through really bad withdrawals about it and I can't sit still yet.
So again, her finances are a little messed up, she has a job, but they have a bill for her now, so if the court would try to take it easy on finance and cost you appreciated, she's gonna need a payment arrangement, but she's prepared to comply with everything else, Your Honor. She realized she needs some help, she's working on doing some stuff, she wants to improve.
Are you going to anybody now? Any treatment?
Soon as I have an appointment to get back on my health insurance. Me and my doctor were talking about taking me back off the Suboxone and giving me the Vivitrol shot. I
Okay,
don't know if you know what that is.
I know what Vivitrol is.
He's gonna give me that.
This is like I'm not trying to make you feel bad, but this is bad stuff. I'm reading this report, and while I appreciate your honesty, you got a problem here.
I do.
You live in Taylor.
I do. I actually just talked to my kid's father the other day.
Ms. Wild's your name?
Elizabeth West,
I know we're along the process here. She went to Sacred Heart.
yes, yes.
What
I
did
got
they,
the verification of her admittance. I spoke with Miss Seiler on the phone. My understanding she was actually gonna be on Zoom today because she was getting discharged later today.
getting discharged? You mean, okay, I
But
got
I
it.
got her home yesterday.
What about her in sobriety, Corey?
I think she would be a great candidate for sobriety court, but she has expressed on many occasions she has zero interest in.
Why don't you want to go into sobriety court?
If it is to do with payments, I don't mind doing it. I really need to buy as it is with my child support getting taken away.
I barely make what I have to pay my dad. Like, I don't make it with a little bit of money I am making. I was doing 3 jobs and it was killing me. I can't do 3 jobs anymore. That's why I relapsed in the first place.
She participated in 23rd District Court Sobriety Court Program prior. I don't know if she was successful or not. I think that that's what plays a role in her decision. And it wasn't just sobriety court. She had expressed no interest in even probation. And again, this would be prior to her going inpatient.
There's no financial legitimate, no.
Yeah, I know, but you can't have it both ways. I mean,
I completely,
ma'am, just please listen to me a second. You can't just say, I can't do that and I don't want probation and go light on the fines. And you dug a deep hole, man.
I know I did.
I mean, you got all kinds of drugs on here. I was almost blushing when I was reading these. So how are we going to wean you off it if you can't afford to if you can't afford the test and you don't want probation and you don't want sobriety court? How in the world
What is
are,
sobriety court?
it's the same thing as what you did in Taylor, it sounds like. It's a
I
drug.
completed, I
Listen.
completed with flying colors there. I had not one bad drop there. I did excellent there.
Well, good, then do ours.
I will, but I can't afford to pay 25 for a blow and 25 for a drop. I don't mind dropping. I don't mind blowing. I just can't pay that high. I owe so much money on the car payment. I pay child support. I have to pay $250 to live with my dad.
Okay, so you give me an option then that you can live with. Because we can help you. I can give you time to pay on this, but we're going to put you through a bond phase. We're going to put you through a bond phase. And in that time period, you're on your own. Once you get through the bond phase, if you get through the bond phase, we have grants that can help with testing, that can help with deductibles on treatment, that can help with sober link devices. We can use grant money to help you.
Okay.
The problem is we can't help you until you're in the program, and we're not taking you into the program until we see how you're going to do and if you're taking it seriously. So I can do this. I can adjourn this for a month and I can put you on the bond phase right now, but do know, what do they pay in the bond phase again?
It is different than Taylor. Taylor, they pay for testing. Our testing is 15.
Right.
Drug of choice, I would probably recommend for Miss Seiler that she actually tests 3 times a week as opposed to 2 with a
So it's
sober.
gonna cost you $45 a week to test. I get that that's a lot of money. But we can't have you in a sobriety court or drug court if you're not testing. We can't verify that you're remaining clean. Now, I would have to tell you, based on what I've read here, I'm not trying to make you feel bad. This doesn't make you a bad person. But your life depends on this.
To be honest with you, going to rehab, I'm scared being home because I have to help with that talk off.
All right. We can help you. You can't use that language in here, but we can help you. Let's get her on a bond phase. Let's try to move this one through quickly. We're gonna get you on a bond phase. We're gonna set you up. You're gonna listen to Ms. Wild. You're gonna do what she tells you to do. I'm gonna adopt all the bond conditions that probation's recommending. And we won't make it a long one. We'll just set this out for a month. I might have to go to like whatever the second Wednesday is of the month or something, Heather. So give me that as a sentencing date in July. And we can help you. You gotta want to have help, but we can help you. We had a great session this morning. I wish you could have been here and seen that. I really do. We're gonna set a sentencing date in a month. Give me a date if you would, Heather, please.
You are off on that second Wednesday, the 8th, so we could do the 15th.
Yeah,
Or
let's
okay.
do the 15th at 8:30. Listen. Are you gonna try to work at State Ridge?
I go back Friday.
Okay. You're staying with your dad and brother, right?
Yes.
You can turn your life around here. You gotta stay away from this stuff. That's what we're doing, July 15th at 8:30, okay? All right, you're gonna go down the hall, get your notice, and you're meeting with Ms. Wilds. Give it a chance. Give it a chance, please. Hang on, is that side? Yeah, that goes with that one. And this one goes in Matisse. I don't know what I'm doing. Wait out there still. Amberlyn Matisse, 24B1475557B.
Good morning, Judge and staff. John Graziani here. We have Amber Lynn Matisse. Ms. Matisse, to my left, please identify yourself.
What is she going to do on this?
Judge, she intends to plead guilty of the.
Is that right, ma'am?
Yes, sir.
That's what you want to do?
Yes,
If you plead guilty here, since you've absconded, you could get the 90 days. You understand that?
I do.
Did you sign, read, and understand the advice of rights form here today?
Yes.
I'm gonna need Jessica, for Jessica on this.
Jessica's out.
Yeah, I know. So just tell them whoever's available, probably. If you plead guilty, you're giving up all those rights and we're not going to have a hearing. Do you understand that? All right, to the charge to fail to refrain from consuming alcohol or drugs, testing positive for marijuana on October 16 to 25. How do you plead?
Yes.
Did you test positive for marijuana on October 16 of 25?
Yes.
Had you consumed marijuana, say within a week preceding that date?
Yes.
Anybody forced you to plead guilty?
No.
Your plea is accepted to that charge. There's only one count. You only had 2 prior technicals, but again, because this was an absconding, she could get
Understood.
90 days. All right, let me check something here before we're gonna get probation in here. What kind of controlled substance was that again? It's not on the citation. Why didn't she show up here? Can you tell me?
Judge, she just became nervous and overwhelmed. I had a good deal of time talking with her, and she has tremendous responsibilities. She is the mother of 5 children, and she lives.
Are you married? Is she married?
She is not married. She is living with her fiance. She's essentially a stay-at-home mom.
How many children have you had by how many?
It's just 5 children with this gentleman.
Okay, you just haven't been married,
Yeah.
but you live with.
Yeah. I'm sorry, Steve.
Who gets married anyway these days? Although I believe.
I'm waiting on.
I'm taking the fifth.
I'm looking at us.
I'm waiting.
No, but no.
All right.
Judge. She suffers from schizophrenia, PTSD, severe anxiety, major depression, or manic depression, and she's overwhelmed, and she doesn't didn't have the courage to show up. And again, this is a situation where we're asking for mercy, Judge. She has been taking steps to take care of her mental health. She sees a therapist 2 times a month, in addition to a psychiatrist that's obviously taking medications. And we're asking, in lieu of any jail time, that she be given additional probation. It's my understanding that she has a separate charge that arose Flat Rock, which was public intoxication. No, it was original public intoxication. It was reduced to disorderly.
I think so.
Okay, it appears it was reduced to disorderly. That's a non-reporting probation, and anything that's given, Judge, I hope coincides with that separate charge.
Ms. Wilds, your name?
Elizabeth Prosecution, Your Honor.
Anything you'd like to say, ma'am?
I am looking.
Oh, no, I was asking her for.
Oh, sorry, Judge.
Just, I apologize for waiting for its time, my not showing up, and truly apologize.
What had she done and not done?
Yes, Your Honor, I'm looking at Miss O'Donnell's notes. She did complete 34 total hours of community service. I believe she was given additional hours of community service for her first violation, which was a positive chemical test as well. There's proof that she attended some treatment, but not completion. So there is at least progress towards treatment, but again, no completion. Testing is kind of what you see there, Your Honor, as far as her being violated with a confirmed positive on this violation and a prior violation as well. I'm not sure if monies have been paid. The last communication that Ms. O'Donnell had with her was back in September 25. before, I think Ms. Matisse absconded. And I did not have a chance to look, but there is a note here that she was sentenced on that new charge in Judge Hessen's case on the public intox, but I did not get a chance to see what those terms and conditions were.
Okay.
Judge, she does owe money, but she has indicated to me that she's completed, that other program, the counseling.
Who's Jerry Knudsen?
Thank you, Dan.
He posted, first of all, I need a first page of a register. And can you hold on? Yeah, but you never showed up on a case out of, Taylor, an assault case that emanated from January, that, let's see, I don't know when it occurred, but
Yeah, I didn't.
hang on one second. You got a warrant out of Taylor since January, I'm sorry, Lincoln Park, since January 12, 26 on an assault case, simple assault.
Judge, I was not aware of it, sir.
That was.
That was what?
Did you have that charge?
You didn't show up and you got a warrant out for your arrest.
I'm trying to figure everything out. I called up there and they gave me the walk-in days that I can come in and do. To go figure that one out.
Take care of it.
Take care of like everything that I've been trying to do is take care of everything, so I'm looking away from my 5 kids, cause I'm the only person that can take care of them. The dad has to work, so he can make the money to take care of them. They don't have like a.
Judge, very briefly,
Let me just say this before we go on. I have no choice but to revoke her 7411 status and enter the conviction. Now I'm gonna re-sentence her. I'm gonna listen to whatever you have to say.
Judge, this is why it's that I get where you're coming from. However, you mentioned, however, this young lady has so many issues that have to be addressed, and she needs more extensive counseling, with responsible medications. I ask that you continue the 7411 status, Judge, because again, she's been overwhelmed. She had in addition to all the issues she's gone through, she had a mental breakdown in the past 6 months, which when her husband was off work, she went to live at a motel just to get away from all the stuff for about a week. So I hope you understand what she's going through emotionally. Again, she was wrong for what she did, but at the same time, there's extenuating circumstances. I mean, she's 28 years old, has 5 children, and it is balancing. What a tremendous balancing act, Judge. That's all I'm asking for. Obviously, no judgment, sir.
Glad you got that in there.
I mean, that takes full responsibility for all my wrongdoings. I'm just trying to make it right now. And I'm sorry that I wasted your time, not on the man.
I don't worry about my time. I don't know why everybody seems to be worried about my time. This is what I do for a living. I'm not worried about the time. How many hours of community service has she done?
She's completed 34.
It shows a concerted effort to try to take care of things, Judge. She's
So if I send you for a drug test right today, right now, what am I gonna see?
Just my prescription for.
There's gonna be nothing other than that's which has been prescribed by a physician.
Yes,
But she did indicate the marijuana, Judge.
Why are you staying with marijuana if you're pregnant?
well, no, I haven't smoked in the last couple of days, but
When did you come down pregnant?
I just found out like 2 days ago. I missed an OT in
I
my.
don't need to get too in depth on this, okay?
There's nothing like that would be good about stuff, but I do not have the money to take the field test.
What's your husband do? I'm sorry, your father.
He does construction.
Sounds like he's on the laborers council, with the highway, for the judge.
Yeah, we just haven't paid it, we found out a DTE, so I know I don't have money today, we'll just pay it. I'm sorry.
I don't want to get too in depth. Did you go into the mental health facility?
She did not go in a mental health facility. A friend of hers suggested that she go get away, not to do anything stupid, but to get away like a lot of people need to when they're having a heck of a difficult.
How long were you in this hotel?
For like,
What did you do when you were in the hotel?
I just relaxed and like tried to figure out my life, you know, like I relaxed, like trying to get in my head, you know, I get overstimulated really easily. Just rather say the one part.
She's overwhelmed, Judge.
I don't need you to go into any more depth.
My schizophrenia was back up with them. That's as far as I probably go over.
Why aren't you getting yourself some mental health treatment?
I work with a therapist twice a week, and I go to a psychiatrist once a month. Not twice a week, twice a month, and then I go to a psychiatrist once a month.
How long you been doing that?
For the past. I think I spent back up for it, but I quit for like a year. Then I thought I made something better, but it obviously made myself worse. And, I started writing. But so far, I've done therapy for like 4 years.
And how long, are you telling me consistently you've been at it 3 times a month between the two?
Yeah. Consistently.
When's the last time you went to either one of them?
This, my psychiatrist, I just seen him on the 8th, and my therapist, I just seen her on the May 22nd.
What is that?
I don't know what that was.
Sounds like a train, another train.
I think it was.
I'm gonna still revoke her status.
Thank you, Judge.
I'm gonna give you 4 days jail. I'm gonna give you credit for 4. You gotta promise me you're gonna keep going to those 2 though, okay?
Going to,
Yeah, the mental health treatment and your psychiatrist.
how can people swear?
You gotta get your life in order, okay?
I,
All right, that's it. I'm closing the case. You can tell your father of your children. I gotta think this through again. They changed everything. I think they get the whole thing back, Heather. Mr. Newsom will. I don't know, you know. It used to be 10% and they changed that and there are never enough changes. I just give them all the money back. I don't think we're supposed to keep any of that. Okay? So you can tell the father to call up to the court and he can dial extension. What's yours, Heather? 234 or what is it?
228.
671-0201. Can you write that down for her?
I am, Judge.
Extension 228. You can talk to Heather and she'll tell him how to go about getting this.
Judge,
Okay?
thank you so much, sir.
Good luck. Thank you. Motion or on your brief or memorandum here, you indicated that Buds LLC and Temersich Erda Namunk were defendants. And I don't think he's a defendant. He was never charged. It's just Buds LLC. So I just want the record to clarify that unless you disagree with me.
No, in fact, the caption is Bud's LLC.
Right. Well, but I'm just saying, when you put it in on your memorandum, you included both people.
Oh, okay.
And that's fine. That's fine.
Thanks for the clarification. Yeah, no, I understand. I'm representing Bud's LLC.
Okay. So I'm ready to rule unless somebody has something else that they want to say. I heard argument. I asked you to brief it. You have. And I'm going to go ahead and make my ruling unless, like I said, somebody else has something that they want to say.
Yeah, the only thing I would say is, I didn't see the memorandum filed. Bully Carter before I filed mine, and I didn't do a response to it, but I just noting that in the argument, she's pointing out that the NIT had the local road became county roads, and pointed out that shall be county roads in all respects and for all purposes. And I only bring that up because, to then go on and say that, because it's a Class B road, it doesn't have to be posted. I think the fact that the county takes over the roads suggests we don't have any conflict between who's got the road, right? It's the county that's responsible and they should be maintaining signs. On that point, there was one other thing that I think we had a disagreement over. I understood Officer Paul to testify that the sign at Sibley and Telegram will not conflict. That it was the way it is now. And I showed that in the exhibit, the backside of that sign. Ms. Foley Carter stated in her memorandum. At the end of the paragraph, Officer Paul testified at the formal hearing that the sign at Sibley Road was fixed. So I just want to point out how important that is to your life. But, and I don't have the method of being able to look at but my notes were that he said was not fixed.
Okay, thank you. Do you have anything in response?
Just in response, I did just speak with Officer Paul, and he did confirm that it was flipped during the entirety of frost knowledge, including this motion.
I don't know. Okay, fair enough. But I'm ready to rule unless somebody has something else to say. Okay, you guys can have a seat. All right, so and I did read this, on March the 18th of 26, Officer Ken Paul of the Downtown Township Police Department issued a citation to the defendant, Bud's LLC, for a truck and trailer he believed to be operating overweight in violation of the spring weight restrictions known as the frost law. Those weight restrictions went into effect on or about February 16 of 26 and were in effect on the date of the issuance of the citation, March 18 of 26. Officer Paul observed the truck and trailer on King Road near Dix. The truck and trailer were being operated by Erden, and if I'm mispronouncing this, forgive me, sir. Erden Namunk Mercic, and is that how you pronounce your name, sir?
Yes, sir. Yes,
Okay,
sir.
I'm sorry. So that truck was being operated in the area of King. He observed the truck and trailer on King near Dix, and that area of King, being between I-75 and Huron River Drive in Brownstown, is in a frost-restricted road with seasonal weight restrictions. All 5 axles were determined to be overweight by Officer Paul, and the actual gross vehicle weight was determined to be 72,650, while the maximum for that time, according to Officer Paul, was 43,810 pounds. Citing MCL 247-669, that's known as the McNitt Act, the township argues that roads located within Brownstown, like King Road, are county roads, and that the Wayne County Roads Division has jurisdiction over their maintenance, including the posting of signs. Plaintiff further argues that defendants Plaintiff further argues that defendant's argument that MCL 257.7262 requires that appropriate signage is recorded on designated highways and streets, in this case, involving seasonal frost law restrictions, is without merit. The township argues that King Road is a non-designated road and does not require individual posting of signs. Exhibits B and C attached to the township's memorandum reflect that Wayne County has published a listing of roads, including King Road, where the truck and trailer were being operated, is subject to seasonal weight restrictions. There is also evidence that notice of seasonal weight restrictions is and was published on the website of the Michigan Department of Transportation website, the County Road Associates of Michigan website, and Brownstown Township's website. Defendants correctly point out that while Officer Paul cited the violation under MCL 257.724, that the applicable statutory citation should have been MCL 257.722, as that section involves seasonal weight restrictions. Clearly, the defendant did have adequate notice of the charge from the beginning, as the entire hearing without objection involved testimony and evidence regarding a violation of the seasonal weight restrictions. From the beginning, the defendants were aware of the charge and the fact that Officer Paul cited MCL 257.724 is not fatal, and the court will permit the township to proceed under MCL's 257.22. The defense argues that the township's case must fail because MCL 257.726 parent 2 and parents requires that, in part, quotes, any prohibitions, limitations, or truck route designations established under subsection 1 shall be designated by appropriate signs placed on the highways or streets. The defendants argue that appropriate signage advising truckers of the seasonal weight restriction should have been placed at appropriate locations to advise truckers of the seasonal weight restrictions. Defendant further argues that there was a sign, quote, flipped. Maybe I misunderstood, but there was a sign flipped over on April 8, 26. That was the photo that you took, Mr. Knight, when you showed us. I believe you're correct, at the pre-formal hearing. On the northwest corner of Telegraph and Sibley, when sometimes I get so old I can't even read my own writing. That's terrible. But at any rate, I think what the defense is arguing here is that's evidence that the county knew they should have posted signage, whereas the prosecution argues, or the plaintiff argues, I should say, that was simply done as a courtesy, and they need not have been doing that at all. So we have this conflict. Was signage required or was it not? And I have to tell you, as well as I think you did on this, Mr. Michael, I tend to think that the specific language here and I'm going to so find of MCL 257.722 subsection 8 does not require signage if they're published on the website. And at the latter part of subsection 8, it says, quotes, and I'm quoting the statute now, the state transportation department and each local authority with highways and streets under its jurisdiction to which the seasonal restrictions prescribed under this subsection apply shall post all of the following information on the homepage of its website, or if a local authority does not have a website, then on the website of a statewide road association of which it is a member. A, the dates when the seasonal restrictions are in effect. B, the names of the highways and streets and portions of highways and streets to which the seasonal restrictions apply. So again, I cited already, and the reason I think that if there was an intention by the legislature that they also post signage in the appropriate location in light of that language, that they would have done so, that they would have enacted another section of this that is essentially said, not only are they posted on all these websites, they're also to post it in the appropriate locations. And here, since it's stated, the commissions, various commissions here, the Michigan Department of Transportation and the Wayne County Roads Commission and the township published it on their website. I think that satisfies the requirement. And it was incumbent upon the trucking outfit to ensure that they were driving in an area that was seasonally restricted and adjusted the weight or taken a different route. So with that, I'm going to find the defendant, Buds LLC, responsible. Have you calculated the fines on this?
$4,207.50 plus court costs, which I believe are $140.
Let me talk to you two in chambers real quick, okay? Let's go back there right now. Go off the record.
This case highlights the importance of a fair and balanced justice system. Throughout the hearing, the judge took the time to review the facts, listen carefully, and ensure that every decision was based on responsibility and the rule of law. Courts play a vital role in giving individuals a chance to be heard while also holding them accountable for their actions. The judge's approach reflected both firmness and fairness, demonstrating how the legal system works to encourage positive change while protecting the integrity of justice. Moments like these reinforce public confidence in the courts and the principles they uphold.
Kevin Prince. I don't have the file, though. I need the file. We have Kevin Prince's file, John?
No, we weren't given his file.
I was just giving the blue back.
We got it. Can't do things without files. So,
Pam was.
Heather, I need the file on,
It's a probation, so Beth, she didn't get the file, it's the blue back.
yeah, Heather, I'm gonna need the file on this, please, okay, Kevin
would-
Prince? It's 25B 726-159. He's in my sobriety court. I'll start the arraignment without it. Sir, your name. All right, so I saw you this morning. I said I couldn't really talk to you about it because we had a status review. And I went ahead and said we'd handle this when I came in. What I have is that on June 7th, that you were positive for alcohol on your interlock device as follows. June 7th, 10:26. I'm sorry, Mr. Graziani. I did tell them to set him up with a lawyer. Your appearance.
Okay, John Graziani, bringing on behalf of Kevin.
So you haven't been arraigned yet, but I'm going to go ahead and indicate for the record that they think that you were positive for alcohol on your interlock device on June the 7th at 10:26 a.m., 0.058, 10:27 a.m., 0.049, 10:28 a.m., 0.042, 10:29 a.m., 0.045, 1:15 p.m. on that date, 0.027, 1:16, 0.025, 1:17, 0.026, 1:20, 0.027, 1:21, 0.024. And then the next blow, the next day, you were, according to them, clean. There was 0.000. So with that, that is the charge. If you plead guilty at any time here, or if you're found guilty, you could get 5 days on this. This would be a first technical violation. Do you understand everything I've said? All right. Did you sign, read, and understand an advice of rights revocation and probation form?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. Mr. Graziani, how's he going to proceed here?
Judge, we waive the formal reading and he will be pleading guilty to the violations.
All right, so you want me to enter a not guilty plea for purposes of
Yes.
arraignment?
Yes.
Okay. So, sir, do you understand what your lawyer has just said?
Yes.
Call in Beth, please. If you plead guilty here, you understand the possible penalties.
Yes.
You understand your rights.
Yes.
If you plead guilty, you're going to be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge that you tested positive on the interlock device for alcohol on June the 6th, on those dates and at those times. 10:26 a.m., 0.058, 10:27 a.m., 0.049, 10:28 a.m., 0.042, 10:29 a.m., 0.045, 1:15 p.m., 0.027, 1:16 p.m., 0.025, 1:17 p.m., 0.026, 1:20 p.m., 0.027, 1:21 p.m., 0.024. How do you plead to that?
Guilty to that.
Did you consume alcohol?
Yes, sir.
What did you consume?
Beer of non-alcoholic and then 4 shots of tequila.
Non-alcoholic beer and 4 shots of tequila?
Yes, sir.
Was it on an empty stomach, sir?
Yes, sir.
Are you on probation or parole?
Yes, sir. Yes.
On any other report?
Oh, no.
Anybody force you to plead guilty? Thank you. I'll accept the plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. I'm going to need to wait for Ms. Wilds. There you are. Thank you. He's pled guilty. Your name.
Elizabeth Occupation, Your Honor.
All right. Let me just make a note here, please. Give me 1 second. All right. would you like to say?
Judge, this is a gentleman who's had long battle with alcohol. He had a case when he was 21 years old, and obviously he concluded in 7 years since his previous one was at the age of 31. He made a mistake. We're asking for mercy. We're asking for no jail time, and also continuation of Mr. Prince being in the sobriety court program. He is a hard worker, Judge. He has several children that he's supporting with his fiancee. He works at Empire today as a carpet installer, and he puts in time. He's a hardworking guy. And, again, mercy, Judge.
Anything you'd like to say?
Your Honor, I apologize because that's very myself to feel me. There are my kids, girls who dealing with the stress, abuse, by the floor. I just slipped up and willing to do 100% against this right. It's just got a bad time.
All right. My concern is, when did he last blown before? He last blown at 8:36 on June 6th, right?
June 6th at 8:36 PM was his last all zeros before he attempted to start his vehicle on the assault.
What troubles me is that you were trying to get into a car and drive. And I know you weren't at the legal limit, but you can't do that.
Judge, excuse me very quickly. Mr. Prince, although he screwed up royally, was moving a car. He was not driving the car, so it was in the driveway. He simply moved it over for a person. They had to get the other that. That was stupid. I don't know how much drinking was done, but he had moved the vehicle. Is that correct?
Yes.
You were not driving on the road.
I wasn't driving to the other side of the driveway at home.
What do you think?
It does concern me. He wasn't able to move the car. He couldn't, he could not move the car. It was hard with the start. He actually, and that was at, he had to wait. So he attempted to blow into the device at 10:30 in the morning roughly. And then actually spent about, I'm gonna say 3 hours. And then was able to move the car, because he was gonna be under the limit come the 1:21 PM. So it took a while for that alcohol to come out of his system before he was able to even start the car. But during that initial time frame, it was all failed. He was not able to open it, or excuse me, able to start.
What would you have again on the breath or blood result at the time of this drunk driving? It was about a 0.42, right, Kevin? The time of the drunk driving, this when you had a kid in the car,
Yes.
wasn't it about 4.42?
461.
461. So you're struggling. I get it. You have to be careful. This can't go on. It troubles me that you were still trying to get into a car. I don't care. And I don't care if you were just moving the car or not. I mean, I get it. That's what you're telling me. But you had a 4.6. You were trying to time it. You started drinking after your last blow at 8:36. I'm not going to send you to jail. So I don't want you to get all nervous on me. You're not going to jail. But you can understand why I have concerns. I think that might be the highest one I've ever seen. I could be wrong. There might have been one at 4.8. But you can understand. I mean, when you get to over 4, wow, you could be dead, comatose. You follow me?
Yes, sir.
So let's just do this. He's going back on the sober link, okay?
Yes, sir.
You're to serve. I'm not going to make you do court work. You're going to do 10 hours of community service, and that's to be completed by, and by the way, You know, let me just finish. That is to be completed in this case by June the 30th. Defendant to be on sober link.
Judge, you mean July the 3rd?
No, I meant June, what did I say? I
You said
meant-
June the 3rd, sir.
I'm sorry, I meant June the 30th. I wrote down June the 30th. My apologies. Defendant to be on sober link device at own expense. At own expense. Until July 28th. And I hate to do that, but I'm really worried about you. You're such a likable guy. You're starting to take shots at tequila. Come on. Let's get this under control, okay? Cost of $50. Can you think of anything else?
He'll need a 1 month extension,
No.
on his, phase. And I didn't know if you wanted to address anything with his sobriety court restricted license, Judge.
I know. What, remind me, I don't have to do anything.
You don't have to, it's up to your discretion. They will obviously bring that up when he has his DLAD hearing. When he goes to hopefully apply for his full license, but we don't have to in this circumstance.
What's the date I have to extend phase 1 to?
At least until, September 7th, Your Honor.
Why September 7th?
90 days clean from June 7th when he was positive. That's a scale requirement.
I know, but they're a little harsh with that. I have to do it from today, or can I don't remember. Can I do it?
It's positive, so June 7th.
It was a sober link. I don't have, I mean, interlock. I just can't justify trying to get around that. I'm not going to. I'm sorry. Phase 1 extended until September 7th. I'm not going to take any action on your interlock, but I'm telling you, if this happens again, I'm throwing you out of the program. And I'm talking about especially trying to get in a car. You're saying to move it. I don't have any proof of that. I don't know if you were trying to move it or not. You're a likable guy, but we have a job to do here. That's what I'll do. Thank you very much. Have a good day. Set them up with the sober link. It's got to be at your expense. That's why it's a little worse, too, by the way. Thank you.
Thank you, Your Honor.
All right, let's call number Elverio. She here? 21W827645.
Michael Carmen, P7384 on behalf of the defendant.
Your name?
Trinity Alberio.
So she didn't show up for a review hearing. I gave her,
phone out of here. Gotta go.
I gave her another chance. And I asked her to show cause as to why the conviction should not enter. The conviction was for assault under HIDA, prepare to appear for a review hearing and a violation of law. Some kind of a public peace offense out of 23rd District Court. Can you tell me what the status of that was, or does she, how she wishes to proceed here, Mr. Carmen? In other words, I want to be clear. I can overlook your failure to appear for the first review hearing. I don't understand why you didn't appear for the show cause back on April the 20th of 22. And it's a little late for me to set aside the conviction at this point. Anything you want to say?
Your Honor, I believe as far as our case went, she thought she was done with the terms of probation. She didn't get any type of indication from her probation officer or from the court that there was anything outstanding. So I think in her mind, she didn't believe she needed to appear any further because she had heard from anyone on probation for quite a while. As far as you said, is there a warrant showing on the Taylor? I might have overlooked that.
No, let me just see. I What happened is I require them to appear. There's still a warrant out of Taylor. Still a warrant out of Taylor. Well, wait a minute. This is old, April 12 of 22. Can you run the lien on her, Heather?
Yes, Judge. There's not an updated one in there?
There's an old one, unless there's a new one that I'm not
They
seeing.
should have
but-
done one this morning. No one, when she walked in, there's not a new one? I can do a new one. It's no problem.
The last one that I have in front of me, let me see. Yeah, I don't. Could be wrong, but
I'll do one right now, Judge. No problem.
good. Yeah, I see her traffic record from June 10th. I don't see the criminal history and lien information.
Okay, do one right now.
There was one, like I said, April 12th, 22nd, April 12th of 22. You know, my concern here is we sent her 2 notices and she didn't show up. And then I entered a conviction for in April of 22. She left with no choice, really. And why didn't she show up? I don't understand. But they had written down, defendant had an open warrant issued January 11, 22 out of 23rd for failure to appear for a pre-sentence report on a public place offense. So it had to be a misdemeanor.
Yeah, I think there's some confusion on my end and maybe it's my fault but I'll ask Trinity, explain to the court what happened to Taylor.
So I just went there recently. My grandpa got a traffic stop and I was in the passenger seat and they asked who was in the car and they ran my name and then I got arrested for the Taylor warrant. This was like a month ago and, so I seen the judge that same day and they told me I'm gonna be on probation now, but I also have to come here.
I already entered the conviction. Can't go back on it 4 years later. She was convicted of it. If it was dismissed, that might be a little bit different. Even though I don't understand her not showing for either court date because that was the address we had on file. And I told you, if you changed your address or place of employment, you had to notify probation. And you didn't notify probation of any change of address. You made this difficult. What were you convicted of?
For what even?
No,
For
for Taylor.
It was disturbing the peace.
Is there a way you can verify that, Heather? Or you got a lot going.
Yeah.
So the
keep it
warrant's
right
not
there
going to
with
be
her.
in lien if that was the case. The warrant is
Correct.
not going to be in lien anymore. If she was pulled over recently and it was lifted.
Correct. There was no warrants on her, Judge.
So it's not even on her record. You know what? What kind of sentence did the judge give you there? I'm ready to sentence her. I'm just going to sentence her on this anew. If you need to look at the file, I'm not going to do much. I just want to know what they sentenced her to. The conviction's going to have to remain, though. It's been on her record since she didn't show up 4 years ago. Not once, but twice. So I'll be glad to just do something here that's fair, and conviction's going to have to enter them.
I just wanted to
You have the first
let the
page
court
of the
know.
register.
She does have a 2-year-old son. She is pregnant.
Can I have the first
For
page?
full-time at a daycare, if the court will consider that. Single mother.
Can you hear me, sir? I need a first page of a register, the misdemeanor register. All right, so we do reflect that the conviction was entered in our records, correct, Heather?
Yes, Judge.
Why didn't you show up? I'm not understanding this. You're not being this irresponsible with everything, are you?
No, not anymore. I'm not sure if I didn't get the notice until after it was already too late.
So you understand I'm gonna send you. Thank you. Right? On the charge of assault, right?
Yeah.
It looks like she's taking care of everything.
Yes, sir. There's no outstanding probation requirement. There's no blue back or anything like that. So I think that's where something can use the file with Michael.
All right. You gonna grow up? I'm asking you a question. You're gonna,
Yeah, I already
you
have.
got kids, right?
Yes,
You gotta be the adult in the room, so to speak, right?
yes.
Right? I'm gonna charge you $60. I'm gonna get you out of here. I'm sure they handled it appropriately over there. Can you pay the 60 now?
Yeah.
Pay now, we're done. That's it, okay?
Thank you, Your Honor.
Thank you. Good luck. You
Thank
gotta, you gotta show up on things, though. Have a great day. People against, he's gonna get, thanks, Mr. Carmen. Thank you very much.
This case highlights the importance of a fair and balanced justice system. Throughout the hearing, the judge took the time to review the facts, listen carefully, and ensure that every decision was based on responsibility and the rule of law. Courts play a vital role in giving individuals a chance to be heard while also holding them accountable for their actions. The judge's approach reflected both firmness and fairness, demonstrating how the legal system works to encourage positive change while protecting the integrity of justice. Moments like these reinforce public confidence in the courts and the principles they uphold.
Buds LLC, 26B150647. All right, guys, your appearances, please.
Edward Nyko, you have Buds LLC.
Mr. Turbish, do you want to say anything? Your name, sir?
Yeah, this is Diamond Dervish. Yeah, I don't have anything to say at this
All
moment.
right, so I'm just making a note. I found your response was charged. I talked to you guys in chambers, said you can either, whatever you want to do. If you want to appeal it, no problem. I'll enter the judgment. Or I invited you guys to talk. She said she usually does it. It's 70%. She's willing to do it now. And now I have a stip form here that I just saw, wherever it is. It says that your client's going to plead responsible to overweight with agreed upon fines and costs of $3,000, correct?
That's correct.
You want to do it or do you want him to do it?
I'll do it.
Okay, and you're authorized to enter to this plea on his behalf?
I am authorized.
On behalf of the company, I should say.
Plea on behalf of Buds LLC.
All right, to that charge of overweight, responsible or not responsible on their behalf?
Responsible.
Plea is accepted. I'll reduce the fines to $3,000. They were gonna be what, about, you said you were gonna do 70%, they were gonna be 4,100 and some, is that it? Okay, so reduced, how long do they need? Can they pay it in a month?
30 days, please.
Absolutely. July the 10th, okay, sir, you have to pay by July the 10th, $3,000, okay?
Okay, will do.
Have a great day. Good luck to you. Thank you very much.
you.
Thank you. Thank you for that, Mr. Nykel. Thanks, Ms. Lady Carter. I've got to take, Mr. Boyd. Do we have a lawyer for Mr. Boyd that he's talked to yet?
Yes.
Where is he? Who is it?
Gentleman in the back.
Was it Mr. Gaith? Mr. Gaith, can you hear me?
Yes,
No,
Judge.
hang on.
I'm here for Miss Russell, Judge, on the retained case.
Hang on, I got him.
Wait. Robert Thomas Boyd, 25B82557. Ms. Foley Carter, your appearance. Your appearance, please.
Rob Harris on behalf of Bronson Township Government.
All right. And Mr. Boyd, your name.
Robert Thomas Boyd.
All right. Mr. Crawford, your appearance, please.
Morning, Your Honor. I'm Bill Crawford, actually. Federal
All right, what are we gonna do here? Tell me you got good news for me, please. Tell me you got good news for me, please.
You know, like last time we were here, Mr. Boyd was ordered to complete the sentencing order in its entirety. He has made some progress. Unfortunately, if we were to go line by line on that sentencing order, he is not compliant with all but the winter storage of the pumps because we're in June. But otherwise, we're not there yet. We do have updated photos. I don't know if this court wanted to see them.
I do, but Mr. Boyd, I want to ask you a question first.
That's good.
You don't have to do this. We've been going round and round on this since June of 25. Hang on one second. I don't believe I've ever revoked your status either. So I'm almost inclined to have to do that today if I'm going to give you more time. You don't have to do what I'm going to tell you to do, right? I'd like you to call your two sons and have them Zoom in.
Pardon?
Have them use Zoom
Oh,
to Zoom into the courtroom. Will you do that for me, please?
all my,
Call your two sons. You have two sons.
oh, yes, sir. They work,
I know. They,
7/12,
so do all these other people. They're zooming in from work. I'd like you to go out. You don't have to. I'd like you to go out. I'd like you to call them. I'd like to have a conversation. You are forcing me to do something that I don't want to do. You're refusing to take help from people that have offered assistance. Sir, I don't want to debate this. You're a likable man. They've been playing with this for 25 years. I'm frankly to the point where I could be faulted for letting it go so far. You're just not going to listen to me. For whatever reason, I don't think you're being defiant. I dislike judges. I don't like, it doesn't matter to me what the reason. You're just not going to comply. So if I can't get some indication from them that they're going to go over there and help you and understand the severity of this, because I have this belief in my brain, and I could be wrong, that you really haven't discussed the seriousness of this with them. I would like you to go call them.
one works midnights.
I don't care. Good, he's off. He's off.
I can't call him this morning.
What?
He's in bed.
Wake him up,
Oh,
Mr. Boyd.
see what I can do.
Get them both on.
The other one, we're not on much talking terms.
You never told me that before. I don't need to know the reasons why.
Yeah.
Call your other son, get him on. Please do that for me. We're gonna give him the Zoom ID. Will you do that for me, John? Give it to him, or Sadie, give him the Zoom ID and have them Zoom in, and I'll pass the case and we'll go from there. I'm gonna ask you to stick around a little bit, please. Thank you. You're gonna go out and call and call him?
Yeah, just wait on.
Go out and call, you're gonna call them. Call them.
Yeah.
Yeah, okay. Robert Earl Curitan. 25B1495698. How you doing, Mr. Curitan? Your name? Okay. You're charged with a violation of probation. Today's the date scheduled for hearing. You had no prior technical violations. I placed you on probation on March the 19th and 26th. The charge, this is a trespass that was taken under section 771.1, and I have 3 violations. Failure to attend the court work program on May 16 and 26. Do you understand that charge? Count two says that you failed to pay your fines and costs as ordered. Bond so in 670, do you understand the charge? Count three, you failed to provide proof of completing 16 hours of community service by May 15 of 26. Do you understand that charge?
Yes.
If you plead guilty or if you're found guilty, you could receive 15 days in jail. Do you understand that? Did you sign an advice of rights and read and understand that advice of rights revocation of probation form?
Yes.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a hearing or a trial. Do you understand that? You do have the right to a lawyer. I think you should get one. I'll supply you one at public expense today. Would you like one?
Yes.
I'll give you one. Not guilty, pleas entered. I'm going to set this for, I'm going to let you go out and talk to a lawyer. Who's this going to be?
I'll give it to Gracian.
Okay. And then you'll go meet with Mr. Graziani and you'll come back in front of you, okay?
Okay.
Good luck to you. Thank you. Have a great day. We'll see you back here in a few minutes. Need his file. Never when the interpreter gets you around, you've seen it, if you would. Amber Elizabeth Russell. 6BO2516. Is she ready on that?
Good morning, Judge. Mazen Gaith appearing on behalf of Ms. Russell.
This isn't scheduled for 10:30, until 10:30.
Judge, I was just retained on this case on Saturday.
Oh, you retained? Did you
yes,
file an
Judge.
appearance? Yes,
I
you
did this morning. I was going to ask for a short adjournment, Judge, just so I can get my bearings on this and hopefully make more
No
informed.
problem.
Please.
She's, so you're gonna let her know though, right?
Yes, Judge.
All right, good enough. I'll just make a note, you were just retained. And, request to adjourn granted. You got a date for me, Heather, in a week or so? Is that enough time?
I was going to ask for July 8th, Judge, if possible.
I'm not
You're
here.
not here.
Oh, okay.
I don't want to go that far. I mean, why are we doing it that far out?
Are you here on the 25th, Mazen?
I'm not, but I can be.
I don't want to, is that the next time you're here, is July 8th?
Yes, because I'm here on the 24th, but I've got a conflict, so that date I need to swap out with somebody else. So yeah, the next date, Judge, I would be here is the 8th.
All right. I can't do the 8th.
I can do the 25th, Judge. It's not a problem.
I'll let you zoom in if you want.
Okay.
I'll adjourn this to June 25th at
8:45, does that work?
8:45, can Zoom. I'd rather she be here in person if you can make that work though, okay?
Absolutely, Judge.
Thank you.
Thank you,
Will do. Thanks. Jacob William McEntee, 26 W841716.
Good morning, Your Honor, to you and your staff, Ryan Gary, P76788, appearing on behalf of Jacob McEntee.
Your name?
Jacob McEntee.
Boy, they didn't give me these deals when I was a lawyer, Mr. Barry, you know what I mean? He's gonna plead to a civil infraction, section 110-106, public nuisance.
Yes, Your Honor, no plea response.
They're gonna dismiss the MDOP.
Yes, Your Honor.
And it says victim consulted has been paid full restitution of $270. Prosecutor requests a $500 fine. That's agreeable to you.
That is agreeable, Your Honor. We would just ask the court for some time to pay if the court would be so gracious.
Mr. McEntee,
Yes, Your Honor.
you have no idea. You should go play the lottery or something tonight. No, seriously. You know, you're getting away with something, striking and breaking victims' windows to vehicles. I don't like this. I don't like it at all. Can you at least tell me that he has a clean record?
As far as I know, he does.
He had one that was taken under
But I do
771.
see that there was something.
Dismissed.
Yeah, he just.
Mr. McEntee, I don't know how your lawyer worked this out for you. He obviously did a really good job. Victim's okay with it, prosecutor's okay with it. I try to never stick my nose in, but I'm telling you, you better walk out of here and realize how lucky you got and then come back here, okay? Because I will remember you. Do we understand one another?
Yes.
So-
Understand, Your Honor.
Totally and completely?
Yes, Your Honor.
To the charge public nuisance violation under 110-106 of the Woodhaven Code of Ordinances, responsible or not responsible.
Responsible.
MDOP is dismissed. Please accept it. $500. Don't come see me again, Mr. Mackin.
Thank you, Your Honor.
Have a good day. Thank you, Mr. Barry.
Thank
Good day. Thank you.
Was there
Oh, I'm sorry. Well, how much time does he need? Come on back up here.
approximately 30 days, Judge?
Can you pay by then?
Yeah, 100%.
We're gonna make it July the 10th then, okay?
Thank you.
If you need more time, you call the court, we'll go on Zoom, or you come in, Your Honor, before the due date, and I'll give you an extension, all right?
Thank you.
Thanks. Have a good day.
Thank you.
All right, what else do I have? I have Mr. Boyd. People against, Nicole Ecker. Nicole Renee Ecker, 26W842-444. Where is Mr. Zelnick? He's got big shots coming in. They handle the informal.
Good morning, Your Honor. Todd Lanzetta appearing on behalf of Nicole Ecker. I am standing in for the attorney of record, Ed Zelnick, Your Honor. And for the record, Your Honor, I was here to cover the fountain sentencing as well. I was told that that was adjourned. I believe.
Well, he asked for an adjournment. I signed that.
You know, he said he was gonna try and get it adjourned, and he texted me back and said, you know, to cover that as well, so.
And I
I'm
did-
learning-
I spoke with the office this morning and let them know that it was adjourned.
Okay, no problem. So
You're in this acronym.
that's all right. So you're gonna plead, let's talk about this one first.
Yes,
We're gonna set it, he filed a motion to set aside the default. I said I'd set it for a motion hearing and an informal hearing, or pre-formal hearing, I should say. And you're here. They didn't write down to set aside the default, but by implication, they're indicating they will. Default judgment set aside, and they worked this out where you're going to plead on behalf of the client, or the client's going to plead to impeding with the distracted to be dismissed. True?
That is correct, Your Honor.
And to that charge, on behalf of the client, responsible or not responsible?
Responsible, Your Honor.
Okay, I'm gonna accept the plea. Let me see how much bond was posted on this. I think it was there a bond posted on this, Heather? I believe there was, wasn't there?
Let me take a look here, Judge.
We always require that. I don't know.
I'm not seeing one on here.
We got how that got by us, but at any rate, I'll accept the plea 155 and have her pay, if you would, by June the 17th, okay?
Thank you, Your Honor.
Do you have anything else?
No, Your Honor.
Have a great day.
Great
Good to see you. Take
Thank
care. Thanks. Bye now. Can we have Lucina up here? Josh, John, there's Stephen Lucina. This is file number 26W8429218. Mr. Okay, your name?
Good morning. Come on now.
How are you? Raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the defendant.
I do.
Sir, tell me your name, please.
Buenos días, mi nombre es John Derriceno.
My name is John Middleton.
You have the right to a lawyer. You're charged with driving while unlicensed. I can give you a lawyer right now if you want one. Would you like a lawyer to represent you?
No,
No, you need a lawyer. Tell me needs a lawyer. Judge says you need a lawyer. I don't know if there's immigration consequences or not. I don't want to know. I don't need to know, but I want you to get a lawyer. Do you mind getting a lawyer?
all right.
All right, let's get him a lawyer, John, and we'll go from there. You also have a speeding charge. You can tell him 11 to 15 over. So I don't know who we can get, but have them do it first thing if they can, okay? Okay, we'll set them up with a lawyer right now. Okay, whoever we have available. Trinity Am.
Thank you, Your Honor.
Thanks. Jamie Antonia Williams Bay. 23W8311736. Your name?
Welcome back.
All right. I'm gonna need Beth in here on this. Do you want a lawyer today? I can't hear you.
I think I do.
All right, we're gonna set you up with a lawyer, so I don't need Beth until the lawyer's done there, okay? Thank you. We'll be right with you. Where's Day Con Chung? Is that, that's 26784-21808,
There's an attorney on Zoom for that
A
one,
and B
Judge.
and C?
Good morning.
Good
Your Honor.
morning, Ms. Carter. How are you? Your name?
Good, Your Honor. Brittany Carter on behalf of defendant.
Okay, so as I understand it, we got an informal hearing with your client. Let's see, I got 808 and B and C, and she only addressed, I think, or he only addressed two of these. No, he didn't. My apologies. He addressed the no proof of insurance, which will be dismissed, motion of the prosecutor, and defective equipment, which will be dismissed pursuant to stipulation again between you two. And your client's going to plead through improper lane use, correct?
Correct, Your Honor.
And you're authorized to enter this plea on behalf of your client?
I am.
All right, to that charge, improper lane use on behalf of him, responsible or not responsible?
Responsible.
Okay, I'm gonna accept the plea to improper lane use, dismiss the no proof, dismiss the improper lane use and the defective equipment. Let me just check his record. How's his record? Bad?
Well, Your Honor, I was going to ask for an impeding, but he said that it was likely that you'd send it back for non-conforming based upon the record. So we'll defer to the court.
He's got to slow down. Be careful. I mean, he's getting ticket after ticket. I hate to be paying his insurance.
I know
I
you're
rarely send things back. I feel like that's beyond it, but I don't disagree that he didn't deserve it. I'll make it $150 and I'll give him a week to pay this, June 17th, okay?
all right. Thank you, Your Honor.
Have a great day. Thank
Thank
you.
you. You too.
What are we gonna do with Mr. Boyd here? Are we gonna get him in with Mr. Red?
This case highlights the importance of a fair and balanced justice system. Throughout the hearing, the judge took the time to review the facts, listen carefully, and ensure that every decision was based on responsibility and the rule of law. Courts play a vital role in giving individuals a chance to be heard while also holding them accountable for their actions. The judge's approach reflected both firmness and fairness, demonstrating how the legal system works to encourage positive change while protecting the integrity of justice. Moments like these reinforce public confidence in the courts and the principles they uphold.
Which one is it?
Sarah.
Who?
Lucina, Yonder.
I don't have it. I have Wicker, Furtado, Moore, and Curate. Maybe I do. Let me see. Might be here. My problem. I got so much going over here. Here it is. My apologies. Lucina. People against Jonder, Stephen Lucina. 26W8429218. Your name?
Come on, now.
Good morning again. You're still under oath.
This week.
Will you ask him his name?
Yes.
And Mr. Crawford.
Good morning, Your Honor. Michael Crawford representing Mr. Yonder Lucina.
Okay. All right. Now, I have a plea agreement here with two charges. Driving while licensed, while unlicensed, and speeding. And as I understand it, the defendant is going to plead guilty to the charge of no valid operator's license on person and impeding traffic, with the understanding that the speeding will be dismissed. Is that true?
Yes.
Is that true?
That's true, Your Honor.
If you plead guilty to no valid operator's license on person, the possible penalties are up to $100 fines, 90 days jail, costs, or all those. If you plead responsible to impeding traffic, that is 0 points and it won't go on your record. Do you understand that?
Yes.
Say, yeah.
And if you plead to those two charges, I'm going to dismiss the driving while unlicensed and the speeding. Do you understand that?
Yes.
Possible penalties on the no ops. I told you up to 100 fines, 90 days jail, costs are all those. And I want you to understand, if you plead guilty to a misdemeanor, and I don't want to know your status, there could be immigration consequences involved. Do you understand that? Did the interpreter read this advice of rights form to you, and did you read it and understand it? You also have a Spanish advice of rights here that you read, correct? And you signed? And you understand if you plead guilty, you're giving up all those rights? To the charge of no valid operator's license on person, how do you plead? Were you operating a motor vehicle in Woodhaven on May 13 of 26? On Hall near Grix in Woodhaven? Did you have a valid operator's license on your person?
No.
Are you on probation or parole?
No.
Anybody force you to plead guilty? To the charge impeding traffic, responsible or not responsible?
I'm sorry.
It's possible.
The plea is accepted to no valid operator's license on person. The plea is accepted to impeding traffic. The drive while unlicensed and speeding are dismissed. And nobody's forced you to plead guilty, correct?
No.
All right, let's proceed with sentence. Anything you'd like to say?
Not that other than my client apologizes for breaking law. He won't do it again. He accepts the court's punishment.
Anything you would like to say, sir? You can't drive without a license. $100 fines, 100 costs. 75 victims' rights fee, $50 justice assessment, 3 1/4 or 60 days. $150 on the impeding traffic.
Your Honor, my client paid $400 today. That's for 2 weeks.
All right, so you pay all of it on the impeding. He's going to pay that now, Heather. He'll have another $250 to pay on the no ops. You will owe $75 after you pay the $400 today, and I will give you until June 24th to pay the rest. That will be $75. Do you understand that? Can you do that? Pay the other 75 on the day? All right, you're all set. Best of luck. Andrew Marcus, thank you, sir, for coming. Thank you so much. Go down the hall, tell him and pay his fines. Andrew Marcus John, 263-07024. I have a B file here for operating while impaired. The OWI was dismissed, and that is the only file I have. Your name, sir?
Andrew Marcus John.
All right, he pled to impaired. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, and know that there are no material deletions or additions that were asked for, Your Honor. If I believe you can comply with the recommendation, we ask the court to adopt the recommendation as presented.
Anything that you would like to say, sir?
I made a mistake getting behind the wheel of my truck that night after I left the bar. It was not my smartest decision. And I can assure you, it'll be the last time this ever happens. That ever happens.
Let me just tell you something. You scored in category 4 on the alcohol use portion and 3 on the drug use portion, and that's not a good sign. You're only 22. You had to voice the legal limit. I'm just telling you. You gotta be careful.
Sir.
This is really a high breathalyzer for somebody that just became eligible to drink.
I understand, Your Honor.
Was that a breathalyzer or a blood draw?
It's a breathalyzer.
13 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance if you change your address, your place of employment or home telephone number. You must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing. PBTs and ETGs bi-weekly for 2 months if you're clean. Actually, for 3 months. They don't make it monthly, okay?
Yes, sir.
Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I want you going to AANA once a week until you're in outpatient treatment. We're going to give you a form. You have to go in person every time you go. You have to have a form signed, the form signed to prove that you went. AANA once a week until an outpatient. Once you get in outpatient treatment, so if you got in next week, you don't have to go at all. Do you understand one another?
Yes, sir.
300 fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So your total fines and costs are 6 1/4. Probation fees are $260 for 885. You have a screening fee of $60 for 945. Cost of recovery of $150 for a total of $1,095. I'm giving you 4 days jail. Credit 1, serve 3. I'll let you serve those on the court work program. There's a $35 a day charge for that for a total of $105, bringing your total here to $1,180. Cost of recovery, Mr. Urick, I'm only giving $150 on a breathalyzer and 2 1/4 on a blood draw, just for your information. And if you could have them put those in these files every time and write it on the STIP form, you know, blood draw, ask 225, breathalyzer, ask 150, or whatever you want to ask. I'm just telling you where I'm going with it, okay?
Very well.
So, 3 days court work, you owe 1180. Is that right, Heather?
Judge, I got 1,200.
Yeah, I thought I might have made a mistake on that 685.
We were good up until the court work program.
You're right. It's 1,200. See, they make me look good. You need as much intelligence around me as I can find. All right, so we're with one another.
Yes, sir.
You may be eligible for early discharge. You understand that?
Yes, sir.
After half the time, 6.5 months, you can come in here and apply for early discharge, provided you don't have any violations within the preceding 90 days. And by law, you're entitled to that. You have, again, 21 days to appeal, 14 days to apply for a court-appointed lawyer. And again, if you violate, you could look at 93 days. We understand one another.
Yes, Your Honor.
Can he pay all this today?
You know, my client can't pay anything today. He's not working, but he is looking for work. He's said he informed me that he's put in 100 job applications in the past 30
Why'd you lose your job at K-Don Plating?
I pointed out on accident.
You what?
I pointed out, it's where I went over by half a point and they.
Well, you weren't showing up?
No,
Showing up late?
I showed up 4 minutes late and they.
Well, that wasn't the first time you showed up late.
Yeah, well.
Get to work.
It's happened a few times.
Get to work. Get to work.
Yes, sir.
You're 22. Your dad doesn't need to be supporting you, right? Right?
Yes, sir.
Right? 75 a week. We're gonna start this beginning on. I want you to get going. July the 10th. If you need more time on any of these payments, you either come into the court on or before the due date, or you call the court. We'll go on Zoom and I'll be glad to give you an extension, okay?
Yes, sir.
Good luck. Thank you. Real quick, can I have Brittany Morgan, Brittany Mary Morgan, 25W835492. Is this yours, Mr. Crawford?
Yes, Your Honor.
Come on.
Thank you.
Michael Crawford, representing Ms. Morgan. Now, station name for the record.
Brittany Morgan.
She's gonna plead responsible to this civil nuisance,
That's correct.
110-106.
Yes, Your Honor.
Is that what you wanna do?
Yes.
You gotta get your child to work. I know you're a single parent. She's missing 36% of the school, it says, right?
Last year she was sick a lot.
She had documentation for at least half of that 60% of those
All right.
things.
Well, for the part that you don't have documentation for though, where should she be?
She should have been at school.
All right, so you get her to school. She's sick, that's one thing. We gotta get these kids through high school. They get through high school, they either gotta go back to the 1840s or they're gonna be in poverty the rest of their life, right? I mean, I'm just telling you, unless somebody's got a trust fund they're giving them.
Trust me, I don't keep them home. I don't need to keep them home.
All right, well, get them to school. You gotta get them to school, okay? So this is agreed upon fines and costs of $150 to that charge of parental response, civil nuisance, under section 110-106 of the Woodhaven Code of Ordinances, responsible or not responsible.
How do you plead that? You plead
Oh,
responsible?
responsible.
I'll accept the plea, $150. Please make sure you get them to school. I get the single parent. That's tough.
My client doesn't have all of the one.
How much does she have today?
Your Honor, she doesn't have.
When can she pay it?
She has, she's proposing $50 starting on July the 20th, $50 per month.
Where do you work at?
She's not working right now. You have to explain to the court. She lost her job. She was unlawfully discharged due to discrimination. She's fighting that at 4 through her union. She's expecting that to be successful, but she doesn't have any money.
Good luck. 50 per week, beginning July 27th. If you need more time, you call the court. We'll go on Zoom or you can come up, Your Honor, before the due date. No reason to be scared. I'll be glad to give you an extension, okay? Good luck to you. Thank you. Mark Wicker. Mark David Wicker. Is this one yours too? No, it's not. Which one do you have, Mr. Graziani? You'll be next.
Robert here.
26W842-655A. All right. I need, surety. Okay. Where are you? Mr. Salas, you're good. Come on up here. I was gonna take yours. Real quick. I'll be right with him, I promise. Go ahead, Mr. Salas. How are you? Your appearance?
Good morning, Mr. Rick, English Salas, P348704, Mr. Montfort.
Mr. Wicker, your name?
Wickler?
I'm sorry?
Mark Wickler?
Okay, you all right?
Yes.
Okay, I just wanted to make sure. Counsel, is your client gonna stay out of here?
Judge, we reviewed the pre-sentence report. It's accurate.
Okay. Is there anything you'd like to say?
Well, he's worked 6 days a week at my church for the past 20 years. Case of first.
What does he do?
He's got a totally clean record. He works at a catering facility and also does the lawn and the lawn maintenance in effect on the grounds.
Okay, he's never been in trouble.
Never been in trouble before.
Good.
Judge, I'm in the court for a minimal amount of probation. He did secure and showed the prosecutor both a insurance and the plate that triggered the stop in the first place. He obtained those the next day. I see the concern of the probation department, and I'd ask the court to make it a screening and eval by a counselor, not necessarily, if the counseling people think he needs it, for sure, then let's have counseling, but I don't know that they will. Pretty low breathalyzer on this particular case for a case of first impression for a 40-year-old.
Okay. Anything else? Do you want to say anything?
I made a mistake that night. Never good again.
Okay. I hope you're right. You gonna be right about that? I mean, I don't write these laws, but if there's one case that I probably shouldn't be putting anybody on probation on, it's this. I'm not gonna place him on probation. I'm gonna order that you pay fines. It was an 074. Prosecutor acknowledged it wasn't a real good case. I think at the time of the plea, 250 fines, 350 costs. 75 victim's rights fee, $50 justice assessment. Fines and costs are 7 1/4, screening fee 60 for 785. Cost of recovery. This was a breathalyzer, right? 150, total 935. Serve 2 days jail, credit 1. That means I'm gonna let you serve 1 day of community service. 1 day community service by July the 20th. So you only have to serve eight hours of community service and do the victim's impact panel. I'm not going to order treatment. So 8 hours of community service by July the 20th. Your lawyer will tell you where you can do that in the victim's impact panel. I'm not going to order treatment. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And also I have to fine him on the C file, the expired plate to which he pled, and I'm going to make that fines and costs of $135. So his total fines and costs here amount to $1,070. Can he pay all that today?
No.
How much does he have today? How much you have today?
I can pay all of this.
You sure? Okay, go down the hall, pay that. Probation will still talk to you about setting up the victim's impact panel, all right? Good luck. Stay out of here. Wish you well. Thank you, Mr. Salas. Curitan, Robert Curitan, Robert Earl Curitan, 2625B149569A. Your name, sir?
John Graziani, on behalf of Mr. Middleton.
Your name, sir? What's he going to do on these?
He's going to be pleading guilty to one of the counts. He did complete the community service, the $670.
I know, but did he complete it by May 15th?
He did not, sir.
So, I mean, that's the.
Did you complete it by that? I don't remember.
No, I did.
Okay, I don't want to talk about it, so I'm gonna have to have a disposition on that. He had to provide proof by May 15th.
He did not.
So does he want to plead guilty or does he want to have a hearing?
Judge, he'll plead guilty.
All right, get Ms. Wilds in here. Is that what you want to do, sir? And he's gonna plead a failure to attend the court work program as well?
Yes, Judge.
And also failure to pay his fines and costs as ordered?
He did pay the fines and court.
But did he do it as ordered? You know,
By that day.
It was 75 a week. Just a couple pages.
so you didn't pay your fines and costs as ordered.
But he indicated to me that he paid $670.
I know, but they do it after the fact.
Understood, Judge.
Okay, so if he wants a hearing on that, I'll have no problem. Otherwise,
Judge, no problem. He does have an explanation.
so if you plead guilty here, sir, to these three violations, that would be 3 technical violations, and you could get 15 days. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? All right, as to count 1, that you failed to attend the court work program on May 16th and 26th, how do you plead? Did you fail to attend the court work program on that date? I'm going to ask you to keep your voice up.
Yes, sir.
Count 2, that you failed to pay fines and costs as ordered, how do you plead?
Yes.
Did you fail to pay your fines and costs as ordered to? Count 3, that you failed to provide proof of completing 16 hours of community service by May the 15th, how do you plead?
Yes.
Did you fail to do that?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
All right, I'm gonna accept your plea to all 3 counts. I finally been made voluntarily and understandingly. The pleas are accepted. Let me just check one thing here. And you understand your 771 status, I'm not saying I'm gonna do it. Your 771 status could be revoked and the conviction entered as a result of these pleas, right?
Yes, sir.
Ms. Wilds, your name?
Elizabeth Vice, Your Honor.
He says he's paid his money. He's provided proof of completing the community service, though he acknowledges that he paid his fines late and the community service was late. Is that true?
Yes, Your Honor. His community service was late. He provided proof of doing it for profit. To his credit, he turned it around and he did do it for a nonprofit after that. His monies were paid off the last portion of it today.
Okay.
Judge, with regard to that, I just wanted to emphasize that in fact, it was Mr. Curitan's understanding that in fact, it would have satisfied the community service and it would have been, but nonetheless, he's satisfied.
Okay. Why didn't you show up for the court work program?
My job it started off as 4 days a week, and it turned to 6 days a week mandatory, and I was on a 90-day period. I didn't want to lose my job. So I thought like if I had a next meeting with her, I could just get a different date.
Judge, he's currently working as a, in labor as in an auto supplier in Madison Heights, making $16 an hour. It's his dream to get into an apprenticeship program for being a millwright. Am I correct? When would you start that program? In September?
I mean, that's supposed to be in the fall.
All right, good enough. I'm gonna go light on. Any reason I shouldn't? Ms. Wilds?
No, Your Honor, this stems from, he didn't show for his visit, he did not communicate with me after, the court work program missed. And that's kind of what started that kind of snowball effect, he still owed money, he still had the community service due, so again, just kind of a snowball effect.
I'm gonna order that you pay additional costs of $25, that you complete all your court work program days. I'm not gonna add another one. I'm gonna add 6 hours of community service, which you have to pay by July the 1, or it's complete by July the 31. Complete by July the 31, 6 hours, do the court work program days, which you'll schedule you for, and pay 25 in costs. Can you pay the 25 now?
Yes. Judge, I have a concern.
Who's here with you? What's that? Where's your mom at? All right, nice young man. We gotta keep him out of trouble.
Yes.
All right? I'm sorry, what did you?
Hard worker, Judge, and thank you for your understanding.
Are we all set? Can you pay the 25 now?
Yes.
Okay, you're all set, and then you'll meet with Ms. Wiles. Thank you.
Judge.
Evan Samuel Hurtado. Evan Samuel Hurtado. Do you have a lawyer with you, sir?
Yes, sir.
Who's your lawyer?
Mr. Crawford.
All right, why don't you go get Mr. Crawford? And I will, well, let me see here. Give me 1 second. Eric, just have a seat and we'll see when Mr. Crawford comes in. Eric, Johnny Moore, real quick, 26W843-009. Where's that one? Do I have Jermaine Fletcher here? Come on up, sir. Jermaine Fletcher, have a seat at the table. Eric Moore, come on up to the podium. Your name?
Eric John Moore.
You're charged with open house party and you have the right to a lawyer. Would you like one?
Yes.
All right, we'll set you up with a lawyer. Try Mr. Graziani for me, John, if he's available.
Okay.
All right, I'll be right with you. So you go over there, we'll set you up with lawyer. Jermaine Allen Fletcher, 25W83907A. And I'll be right with you, Mr. Lansayer. Your name?
Very Fletcher.
All right, you're charged. Did you meet with Mr. Crawford?
Oh, no, I just met with the process.
So you waive your right to a lawyer then? You don't want one? We have Mr. Crawford's name written down, but then there was somebody crossed it through, with a green line on waived. So do you want a lawyer? You sure? All right, so you met with the prosecutor, you're going to plead guilty to no valid ops on person, and they're going to dismiss the drive while unlicensed, correct? All right, if you plead to that, the possible penalties, are up to 100 fines, 90 days jail costs or all those. Do you understand that? If you plead to that, I'm going to dismiss the suspend charge. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
To the charge, no valid op, and you still wish to waive your right to a lawyer. I don't want to belabor this. To the charge, no valid ops on person. How do you plead? Were you operating a motor vehicle in the city of Woodhaven on I-75 near west at 10:43 p.m. on the 9th of January of 25, 9th of June of 25?
Yes, Your Honor.
Did you have a valid license on your person? Are you on probation or parole? Anybody force you to plead guilty?
No.
Who is Keisha Glimpse?
I was a female acquaintance of mine.
She gonna let you apply the bond, or I hope you have the money.
Yes, the bond is good. They told me that I can apply the bond to the court.
She needs to give us consent.
Okay, she did that.
They'll explain it to you down the hall. Anything you'd like to say before I sentence you? Why didn't you show up here initially?
I did come in the first time when I spoke with you at that time.
Yeah, why didn't you come back?
Well, at the time I was on probation and,
You got warrants all over. You realize that? 34th and 35th. I shouldn't say
Yeah.
all over. It's not.
I'm in the process of taking.
Where do you work?
I work at Cooper Standard in Longview, Michigan.
You got to be better about showing up for court, sir.
Yes.
All right. Anything else?
Oh, yeah.
100 fines, 120 costs, 75 victims' rights, $50 justice assessment, 345 or 60 days. You're going to be able to pay that today, one way or the other, correct?
Yes.
All right. All right, good enough. You're all set. Go down the
Judge,
hall.
Um,
Yeah.
Did I miss, Did you address the no insurance? Did I miss that one? I'm sorry.
Oh, my gosh, you have the other money too. You owe money on no proof of insurance. I'm sorry, 25W89007B. You gonna be able to pay that? That's 282. Plus the clearance.
When I was speaking to the prosecutor, he told me as long as bond was paid, that I could cross all of that money's over to the client the cost. So I just need to know what the total was because I believe I bonded out for $625 at the time.
You had, yes, correct. You had actually 482, it looks like, 682. Let me see. Let me just have a check. Yeah, you have 400 plus 282, 682. You apply. I'll tell you what, I'll cut that down for you a little bit. You pay 210 plus your clearance fee on the no proof. How's that? Okay?
That total be all together?
Should be, let's see, 300, I charge you 345 plus 210. That's 650 plus the clearance fee. Should be 690 or 5. Yeah, 345 plus 210 is 555 plus the clearance fee. It should be 600 total.
Okay.
Balance I'll waive of the no proof. Okay? Good luck. Thanks. All right.
Jeez.
He's busy, huh? See if she's ready, and I'm going to take Mr. Rebant here.
This case highlights the importance of a fair and balanced justice system. Throughout the hearing, the judge took the time to review the facts, listen carefully, and ensure that every decision was based on responsibility and the rule of law. Courts play a vital role in giving individuals a chance to be heard while also holding them accountable for their actions. The judge's approach reflected both firmness and fairness, demonstrating how the legal system works to encourage positive change while protecting the integrity of justice. Moments like these reinforce public confidence in the courts and the principles they uphold.
If you come on up here, Michael Joseph Rebant, 6G306-836A and B. Good morning, counsel.
Good morning, Your Honor. Pleasure to see you again. Attorney Ryan Reeves on behalf of Mr. Reband. Mr. Reband, please identify yourself for the record.
Multiple Reband.
All right.
Your Honor,
I'm still telling you, you got to go join. He's got that deep voice. He needs to go join. What do you call it again? What's that called? American Idol.
Yes, that will.
All right. Okay. Well, whatever. The point is, I'm just kidding. You gotta.
Your Honor, today, date, time set for sentencing and review the pre-sentence investigation report with Mr. Reband. No additional corrections, if I may help you briefly.
Yes.
Getting to know Mr. Reband, Mike, as I knew him, he's a hardworking man. I will note that he has now lost his CDL for a year. DTA was able to work with him, but it has cost him his overtime and some of his hazard pay. They are going to keep him, and when he gets the CDL back in a year, he'll be able to go back to that, but it is going to cost him essentially thousands, if not tens of thousands of dollars over the course of this year on top of this case. That being said, Your Honor, he did come prepared to pay all fines and costs today because he recognized he owes a duty to the court. Outside of that, Your Honor, I think it's a very fair assessment, and I think the educational program will be good for Mr. Reband. We're just asking Your Honor to follow along with the recommendations. The one thing we'd ask brought over from Bond is that he does have a fiance in Texas who he visits every other weekend, allowing him permission to travel to Texas for that purpose. We would ask for that. Outside of that, Mr. Reband is ready to go forward today, put this behind him, and hopefully in a year get back to the position, the very nice and lucrative position he had with DTE. And our hopes is that they're going to accept it back.
Good enough. Anything?
I just want to say, I'm sorry, Your Honor, I learned about something you got sitting here again.
The only thing that bothers me is you were stopped and drunk at the scene there, passed out essentially on the roadway. That's the thing that bothers me the most. I'll adopt this. 8 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You cannot purchase, possess, or consume any one of those. You're to submit to chemical testing, PBTs, and ETGs. I'm simply going to make that on demand at probation. Kratom, poppy seeds, and CBD oils are prohibited. consuming food or other items containing those substances will be deemed a violation. I'm going to order that you attend the level 1 alcohol education program with the Victims Impact Panel. I'm going to order that you serve 3 days jail, credit 1, serve 2, and I'll let you serve those by way of community service. 16 hours community service by July the 31st. You can leave the state to go to Texas without the consent of the court. Otherwise, if you're going elsewhere, you have to seek and obtain consent of the court. $300 in fines, $300 in costs, 7.5 victim rights fee, $50 justice assessment, 7.25. Screening fees 60 for 785. Probation fees are 160 for 945. You have cost of recovery of 2.25 because it was a blood draw. 1170 is your total. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal, and you may be eligible for early discharge. If you're compliant at the end of 4 months, you can come in here and request, if you've done everything, discharge from probation. That's pursuant to statute. You say you can pay everything?
You can pay everything.
And then you'll meet with probation here. I sincerely wish you well.
Thank you, Your Honor.
Okay?
Thank
Good
you.
luck. Are you related to Judy? Who's she?
It's my fault, man.
I went to St. Tim's with her. I haven't seen her in years. She doing all right?
Yeah, her husband's serving China.
Oh, no. Jeez. Will you tell her I said hi? And the other case, by the way, that was put here was already dismissed, the PBT refusal. We put that at the top of the step.
Yes.
Good luck to you. Have a nice day. Thanks, Mr. Ramsayer. Good to see you. Thank you. Deshaun Thompson. Deshaun Davion Thompson. You know what, Mr. Crawford? I need about 5 minutes. I got to get off of here. But I want to get Brownstown. Is Brownstown in Judge Hessen's?
There.
Come on in here, Mr. Boyd. Who's your lawyer on this one again?
Crawford.
Mr. Crawford, come on up on this one. Robert Thomas Boyd, 25BA 2557.
You want Brownstone here?
I don't want to bother him if you're in front of Judge Hessen. That is not what my intent was.
Taller, see what she tied up.
Mr. Boyd, your name?
Robert Thomas Boyd.
Mr. Crawford?
Michael Pelton, Mr. Boyd.
What are we gonna do with Mr. Boyd? Did you call your son?
Couldn't get hold of me, I just connected his phone to one of his leads.
He also tried calling his wife, she didn't answer because she's at work.
I didn't know you were married.
No, well, his son's wife.
Oh. What am I gonna do with Mr. Boyd?
I'm very sure, Your Honor, it appears to me that my client is doing every sincere effort that he can in his advanced years and the type of support he has.
No, he's not. I've given him too long. They've been after him for 25 years to do this. Mr. Boyd, I think it's time for you to go to jail, and I don't want to do that.
I don't want to do it.
Why are you not taking care of this?
I took care of a whole lot.
Do you have the pictures that they had?
I don't have the pictures, Your Honor.
Okay.
Pictures.
Only if she's available.
But Your Honor, my client submits that he did get the boat removed. He got the trailer removed.
Yeah, but she just got done telling me he's only done, it's about the only thing he's done that's on the list for him to accomplish when I placed him on probation 11 months ago. And they've been after him for 25 years.
He's on the way.
I didn't get the opportunity to talk with the prosecution to see if we could put our heads together and make a other suggestions.
Well, I mean, this has been going.
I know.
He's not going to listen. You're not going to listen to him. I don't think you're being defiant of me in the sense that you're not basically one of these guys that comes in there and thinks he owns the place. But you're not being defiant. You're just, I think there's some issues here.
What the solution is, I don't know.
Well, the solution is probably, I just got to send him to jail, I think.
Well, unfortunately, when you come out, Your Honor, he's gonna be in the same situation.
I know, but they've been after him for 25 years. You know how many hearings I've had him here on? Guys, can I have your name and can you both count your appearance
Caitlin Fuller Farm, Brownsville Township.
Rob Harris on behalf of Bronson
Can you
Township.
spell your last name for my recorder? You, Ms. Paris.
Harris,
Harris.
Harris.
All right, what are we gonna do? Give me the pictures, please. Let me see them. Did you show them to Mr. Crawford?
Oh, earlier. I gotta say, at first glance, Your Honor, they looked a lot cleaner than the other pictures that were in the file. You look brighter, you kind of see the property a little bit more. We could,
Did say there's progress, just
not as much as one would like, so.
He is making progress, though. Maybe a little bit, right? Looks like the Taj Mahal compared to before, even though it's. You gotta get the vehicles out of there. These are inoperable vehicles. What's this wood pile doing here in the middle of the yard?
When they stole my wood last, fall, I had to buy some more wood. I heat my house with wood. And, I didn't want to put it in the backyard because.
If I give you 2 more weeks, you're gonna have this done?
How about
I know. What do you want me to do? Send him to jail?
I don't know, Your Honor. I know that this has been going on.
I know.
Yeah.
Ad nauseum.
All I've got left is the bushes.
2 weeks. During the review hearing, I can't believe, I don't know what it is about me. I mean, I really don't. I really should have been fed up a long time ago. I mean, he made me send him to jail. How many times you go to jail on this? Once or twice?
Twice,
For how many days?
5 apiece.
Heather, give me a date in 2 weeks, please, or whenever, 3 weeks before I go anywhere and and it's not on Judge Heston's docket. What are we gonna do? July the 1st?
So that, not on her docket.
I want it
will
on my
be-
docket. This should be
your
on my
docket will be
docket
July 1st for Brownstown.
at 8:30. Okay?
Can I just make a note about what needs to be done?
Yes.
Just so that it knows that it's.
Yes,
actually put.
absolutely.
So looking at the sentence, going by line. First, the 2 vehicles that are parked on the grass, they need to be on impervious,
I want you to listen very carefully to him.
must be located on concrete or asphalt driveway surface. They also must be roadworthy, so the flat tires on the RV and cars, those are not roadworthy, so they need to be made roadworthy. The garage was taken down, the permit was pulled, however, there's still no inspection, so it's not completed, so we need to contact the township, have them get out there and make sure it's safe.
Do you understand that?
Yeah, I thought he was the guy I had to have come out and look.
Well, you can set it up with him right now.
No, I'm not the.
Yeah, I know, but can't you help expedite it by?
Absolutely, I mean, and also the cement's still there for the garage, the cement has to be, removed. So that, to get the permit to be passed,
Right,
the cement has to be, so I'm not a building inspector,
right, I know.
but when I spoke with him yesterday, he said he would not pass it because the cement is still there, the broken cement.
I want to keep the cement there, park the stuff on.
The cement is broken, raised.
It's a cement floor from a garage.
I made the orders initially. You need to follow them and go back to the probation order where everything was attached. And then you prepared another order on this case, correct?
We did, Your Honor.
And it's attached to the probation order.
Sure, I also gave Mr. Boyd a copy of the last one.
I know, see, you gotta follow that. You gotta read that. Get your son to help you. Get somebody to help you. But if they don't pass it, it's no go.
What's wrong with keeping the cement?
You talk to them about it. I ordered you what to do and I expect you to do it. 3 more weeks, that's it. I can't extend probation anymore under 771. You're coming to the end of the year.
Just to be clear, Your Honor, 2 motor vehicles off of the grass on concrete.
Correct.
Asphalt and roadworthy, and get the building, passing grade from the building inspector.
Exactly.
The garage, it's all working. There's more that's coming.
There is, yeah, so there's still junk, trash, rubbish, garbage throughout the property.
It's pretty clear. You gotta get rid of all that.
I am.
Within 3 weeks. Go ahead.
There's no trailer storage, so there's multiple vehicles that are being used as outdoor storage. That can't happen in the township. As Mr. Harris stated, the cement needs to be removed from the garage demo because it's all busted up, so it can't be used as like a pad for parking. The grass and noxious weeds need to be taken care of. There's an ordinance where it's what, 6 inches?
It's 8 inches, but I mean, there's weeds there that are taller than me, especially at the side of the house.
You got to get rid of them.
Sure.
That's about it.
Home's gone.
Get rid of it, please.
Slide over that cement. I have to have them to park the vehicles on. They order me to park the vehicles on cement. That cement is fine for parking the vehicles on.
Well, you haven't, he's not the building official.
I know.
He's gonna help you get in contact with the building official before you leave here.
Yeah.
You can explain that to him, and he's gonna come in here and talk to me in 3 weeks. If you don't resolve.
Okay, we'll see what we can do.
Let's get it done. Can't believe I'm not sending you to jail, Mr. Boyd.
Thank you, Your Honor.
Your Honor, I appreciate your benevolence.
Good luck. Sean Thompson. Deshaun Davion Thompson, 26W824-842-863A. And I also have a B file here where he pled MIP.
Thank you, Your Honor.
Thank you.
Michael Crawford, representative.
Your name, sir? Defendant pled guilty to MIP. He also pled guilty to operating while impaired. The real concern is he's 18, at a .126, and he scored the worst. You realize category 5 is the worst on both the alcohol and drug use portion, and that tells us that you've got a very serious drinking problem. I'm just telling you what the score is reflected on based on the answers that you gave on the questionnaire. Do you understand that? All right, counsel, do you have a chance to review the report with them? And are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my clients, Your Honor. There are no material additions or deletions that we're asking. My client believes that he can comply and will comply with these recommendations. We would just ask that the board adopt them, and we would discuss our requested payment of them.
Aren't you working?
He's got 2 jobs, Your Honor. He works at Arby's part-time.
I saw that.
And he also was working with a moving company.
Well, it didn't reflect that in the employment status. It's got him working 10 hours a week, earning $14.25 an hour. That's not enough to put gas in your car.
Well, he's also working at the moving company, Your Honor, so.
How many hours are you working there?
Oh, it's not really up to me,
I didn't ask you that. How many hours are you working there?
Can't give you an exact time, it's like different hours, people have.
On average per week. You work there more than 10 hours a week?
No,
So you're not even working 20 hours for the most part. Come on. Come on. You're 18. You're a big, strong kid, good looking kid. Is anybody with you here today?
Yeah.
Is that your mom? Am I right or wrong, Mom? You live with your parents. How old are your parents? They don't owe you a living anymore. You're out of high school. How much rent you paying? They don't owe you a living anymore. I'm serious. I don't get this stuff going on up there anymore. Jeez. Aren't you bored? What are you doing? There's 168 hours a week. Tell me what you're doing the other 148, and I'm going to assume that you're working 10 for the moving company. What are you doing the other 148 hours a week? I can't hear you. I think it's great that you're in the gym, but you're not going pro at anything, you think, right? Well, then come on. I'm not trying to embarrass you. There's nobody in here, but I don't know. I just don't understand it anymore. I mean, why do your parents owe you a living? I don't think they do. 15 months probation. Have I let everybody finish here? Did you go to AA? Let me see it. Did you show it to your lawyer?
You did not.
Show it to your lawyer. Did he go once a week? So is he gone at least since I arraigned him on May the 27th? He should have gone at least 2 times.
I'm happy to report that he went one time, you know.
Why didn't you go twice? I told you once a week, didn't I?
Well, it was like the complication, but like I was like things I had things to do certain days, and I just kept procrastinating it. So I would wait like a day off.
You seem like a nice kid. You know that? You really do. Mom, you did a good job on that aspect, though. We got to get him working harder, though. The world doesn't owe us a living. You seem like a really nice kid, and you're getting yourself into trouble and you're out drunk driving, and I don't like what I'm seeing here. 15 months probation. I'm going to let that go for the time being. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. Submit to chemical testing, PBTs and ETGs monthly or more on demand of probation. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. AA once a week, in person. Get in outpatient treatment. I want you in outpatient treatment. Once you get in outpatient, you don't have to go to AA or NA any longer. So if you get in this week, you can stop going. Victims Impact Panel, one night put on by Mothers Against Drunk Drivers. Attended, completed. 5 days jail credit, 1 served 4. I'll let you serve those as follows. 3 days on the court work program, charges 105, 35 a day. 1 day of community service or 8 hours. You can do that at any nonprofit organization by July the 20th. 300 fines, 250 costs, 75 victims' rights, $50 justice assessment, 675 probation fees are 3 for 975, screening fees 60 for 1,035. You have a cost of recovery of 150 for 1185 plus your court work program fees. Your total here amounts to 1290. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You may be eligible for early discharge. You get everything done in 7.5 months. You can come in here and fill out a motion to set us for early discharge. You're entitled to it by statute. You need to get more work. $50 a week. We'll start this beginning July the 6th. If you need more time, you call the court. We'll go on Zoom. I'll give you an extension. Otherwise, I expect you to pay that. On the MIP charge, you're going to pay. I'm going to assess fines and costs. I'll cut them down a little bit. Have you pay those in the amount of $150. I'll let you pay those by August the 1st. Okay? That'll give you some time to get some new employment. Listen, you're a nice kid. You got to act like it. Be responsible. Okay? I'm serious. We all make mistakes. Don't beat yourself up. Let's get going here. Time's a ticking. Thing goes so quick, you're not going to believe it. Remember, in 2000, let's see, you're 18. It's 2026. By 2080, you'll be saying, I remember that judge. He's been dead for 45 years. But boy, he was right. A lot of time does go fast. See you later. Go meet with probation. Good luck. Hurtado, Evan Samuel Hurtado, 26W841254A.
Michael.
Thanks for coming, man.
Thank you. Have a good day.
Two.
Michael.
He's going to meet with probation. All right.
I'm Hurtado.
I'm going to read in here Madeline. He pled guilty on May 27th, counsel, to 1 violation. He had no priors, so he's got 1 technical now. And that violation he pled to was having possession of a controlled substance. A failure to attend the 12-step meetings twice a week. So I adjourned it for some reason, which I hope the probation officer will remind me of.
Your Honor, if I could, you had, some doubts about whether my client was remaining clean. So you would order that he test immediately that day, and he did test that day. He came back negative. He's tested 2 times since, and they both felt that it's done.
Good deal.
Hoping the court would take that into
Of
consideration.
course I will. Is that true?
Yes, sir.
Who's this with you?
My father.
Well, thank him for coming. Did you thank him?
Oh, yes.
Did you? You did?
Yes, sir.
Before you came up on the way here or yesterday? When you knew he was coming with you?
Oh, yesterday.
All right, Madeline, how you doing?
I'm good.
What are we gonna do with this young man? Your name?
Madeline Raffles probation.
What are we gonna do with him? Is he all right?
You're gonna have some difficulty.
Jeez. They just got done telling me he tested the next day and he tested a couple more times and he's tested negative.
So he has tested negative. The one test was positive and was confirmed positive. That's what's on the violation.
Okay, because I entered a not guilty plea as to count 1. So he was not telling me the truth. He was positive for marijuana on the test of May the 4th is what you're telling me.
The May the 4th, correct. It was confirmed positive from the lab. It was,
Marijuana,
yes,
okay.
40 times the cutoff level.
40 times. He forgot that. He forgot he used.
Well, we discussed it at the time, Your Honor. He had done a little bit of personal research, and it was his belief that perhaps it was shadow. He was having a THC flashback because his prior use was so high. That was his explanation.
I love that stuff. You know, get technical like that. Huh?
So the issue with that though is that his test prior to that on April 13th was negative for everything.
Right.
So it was not off levels.
It wasn't, it was new use. It wasn't some kind of residual from weeks before, like some people like to tell us, right?
Correct, because the test prior was completely negative for everything.
So you were using.
That's what the court concluded in the last hearing.
Yeah, thank you. Well, then I was right then and I'm right now, not wrong then and right now. So, what else? Is he doing everything else?
We've had a little bit of other difficulty.
Uh-oh,
So,
good thing you brought that. He can go back and get you some clean underwear. What's he been doing?
so as to count 2, he was ordered at the instructional to attend 2 in-person 12-step meetings per week. The whole time he was actually attending via Zoom. So he was not attending in person as he was ordered.
You ever been to jail before?
No,
You
no,
wanna go today?
no.
Why aren't you listening to me?
Pardon?
Why aren't you listening to me? Why aren't you not complying with court orders?
To explain about like the online, like as soon as like when I first got sentenced, I got a message from someone about AA and outpatient, and I just assumed maybe someone from the court was through. But after the second meeting with Madeline, I declared that we have to do it in person.
I told you in person on April 1, it says it here.
Well, again, Your Honor, my client is young, and out here on the internet, there's a lot of bit of communications going on.
I know.
He got
They're all figuring out how they can, how do I say this? How they can deceive courts, right? They got all this stuff on the internet. Tell them this, tell them that. Don't do this, do that, do that. They won't find out. Go ahead, what else?
We've also been having a time regarding treatment. So that's not a violation yet because it was something we were working on. I believe as of today, hopefully it's resolved. He was required to do SUD treatment. He was sending me back a picture of mental health treatment quite a few times. I had to let him know that's denied. He needs substance use treatment, but he did say this morning he's an intake scheduled. So hopefully that is resolved and he gets into SUD treatment.
It is scheduled for tomorrow, sir.
Where?
It's I had a document. It's in Royal Oak, something, but that's already gone.
Why are you going out there? You live in Brownstown, right?
That was the only one that was available. I kept calling and like where I can go in person or in post, and there was nothing that was available.
How old are you?
20, Your Honor.
You graduated, right? Where'd you graduate from?
Wait, from high school?
Yeah.
University of Detroit, Judge Middleton.
You went to U of D Jesuit? And you're getting in trouble like this? Did you go to college?
Yes, I'm still,
Where?
Western Government University.
Western what?
Western Government University, it's online.
Why you wasted your time with that? Give me a, I'm serious. Got this online stuff. Let me see the screening report. You went to U of D Jesuit. I bet that cost your old man and mom some money, huh? What'd that cost? Do you have any idea? What'd that cost, Dad? Can I ask you? Do you mind?
Wait a minute.
Pardon?
Wait a minute.
Yeah.
The reg job.
Now you got an MDOP last year. You were attending Schoolcraft when I sentenced you. Come on. How'd you do in school, high school?
Average.
Well, what is average?
Uh,
Average is about a 3.1 now, if you ask me.
2.8 to 9.
You didn't study very hard. You still got a chance to turn things around. You're still young, but boy, if they put all that money into you at U of D Jesuit, right? Seems like a nice kid, sir. We just got to get him working harder. I'm going to just go ahead and do this. I'm going to go ahead and order 1 day on the court work program. You're to pay $35 for that. You're to pay additional cost of $60. I'm going to go light on you right here, sweetie. I'm going to go light on you here, but I'm telling you, I hope this conversation is going to straighten you out because I'm not going to be very patient with you. Do we understand one another?
Yes, ma'am.
You're going to pay the $60 now, can you?
Yes.
And he can also meet with you to set up the court work. But I'm telling you, I don't like what you're doing here. I'm telling you, Mr. Hurtado.
Judge, do you
Yeah.
want to pay just the 60 today, or are we charging the 35 for the court work
Thank you.
program, or is that something
See,
he
that's
owes?
why I surround myself with people like you. I mean, it's true. I mean, these guys are so great. So it's total 95. You also, I wrote it down 35, but I didn't say it. You also owe the 35 in court work program fees.
You'll pay that.
Thank you very much. Good luck. Thank you. Good luck. Good luck. Good luck. Deanna Purcell. I hope this is my last case.
Judge, you will have another one after that.
Thank you.
But I'll make it quick.
I got it. Deanna Lynn Purcell, 25W8389688 and B.
Hello, again, Judge and staff, John Graziani, I'm going to be having Deanna Purcell, who's in my left.
Your name, ma'am?
Deanna Livingston.
All right, so we have a possession of, they're saying of LSD, it says here. Amphetamines, suspended license and expired plate. Does she stand the way formal rating?
Yes, she does, Judge.
Where's she been?
Judge, she,
Ms. Purcell, where you been?
yeah,
I like when people are honest.
I was pulled over twice in the same night.
All right. I just asked why you didn't show up. I'm not,
she had a separate matter in Allen Park, which was via Zoom, and it overlapped, Judge, and she.
all right, let's quit with this, okay? Because I don't really want to hear stories today, okay? I've had a long day.
I had 2 court dates.
I'm continuing your $300 bond. I'm continuing your $200 bond. No alcohol, no marijuana, no illegal controlled substances. That is a condition of your bond. You cannot leave the state, cannot violate a law. You must appear in court as directed. Again, no alcohol, no marijuana, no illegal drugs. You fill out a petition for a court-appointed lawyer. Where, did you go to Trenton High School or someplace else? Did you graduate?
Yeah.
Good. Pre-trial date will be when, Heather?
This will be June 24th at 9:15.
June 24th at 9:50, okay?
Judge, thank you for your understanding.
I know, but she's,
Judge, she does work very hard as a waitress. And
where do you work?
Pete's Place in Taylor.
Okay, all right. Good luck.
I'll be back in a few minutes.
We'll see you back here. Can I tell you something?
Yes, sir.
Yeah.
Oh, I enjoy it.
It's not, I've got this genie on this, this one here.
No, but as a. The Crawfords.
And
he's got one more.
Okay, what's that?
Okay, just, Mr. Crawford has one more,
Yes, one more.
plus this?
Yes, yep, so we've got two.
And then what are those?
Give up to me now, I take. Time you.
This top one, the hearing at 11 o'clock that never showed, that one right there. I didn't see it.
People against Arthur Charles Hughes, 215B, 76724A. Heather,
I didn't see a thing on there.
would you call up? I'm not going to write on this one. This is a Project Clean Slate. I'm sure it was an oversight. Would you call the defense lawyer that was representing this party and say, hey, the judge said you didn't show up and would you want to reschedule? Would you do
Okay.
that for me? All right, Jennifer Lynn Anderly, 260-150-4358, defendant failed to appear, 285 cash or surety. Jennifer Lynn Anderly, 260-150-435B, 195 cash or surety. Ahmad Ali Amin Baidoon, 260-239-049, 213 cash or surety warrant to issue. People against Keon Brown Bowden, 26W840819B, 219 cash or surety, and on the C file, 282 cash or surety. People against Tiffany Janelle Epperson, 25W841089B, 195 cash or surety. People against Ashley Suzanne, and these were failures to appear on June the 8th. Ashley Suzanne Hill, 266-47739, warrant issued, 213 cash or surety. Demetrius Dante Jamar Jackson Jr., 26W841435, 213 cash or surety warrant to issue. Shalise Renee Jones, 26W841499, 213 cash or surety. Johnny Leister, 26W841189B, 213 cash or surety for failure to appear on the 8th. Thomas Anthony McGuire, 26W841437, 207 cash or surety warrant to issue. Stavros Natira, 26I415235, 249 cash or surety on that warrant to issue. Remy Joseph Range Jr., 26W841394, 213 cash or surety for failure to appear on the 8th. Sean Shirley Robertson, 260-647-688, 237 cash or surety warrant to issue. Olivia Jean Saunders, 26W841455B and A on the B file, 282 cash or surety on the A file.
This case highlights the importance of a fair and balanced justice system. Throughout the hearing, the judge took the time to review the facts, listen carefully, and ensure that every decision was based on responsibility and the rule of law. Courts play a vital role in giving individuals a chance to be heard while also holding them accountable for their actions. The judge's approach reflected both firmness and fairness, demonstrating how the legal system works to encourage positive change while protecting the integrity of justice. Moments like these reinforce public confidence in the courts and the principles they uphold. This dramatic courtroom case centers around a woman who admitted to driving while impaired by drugs and crashing into a utility pole, causing major disruption and shutting down an entire city block. But the judge's biggest concern wasn't just the crash, it was what happened afterward. Despite being ordered to attend recovery meetings, she completed only a fraction of what was required and arrived in court without proof of attendance. As the judge questioned her commitment, the hearing quickly became tense. While acknowledging her personal struggles and responsibilities, the court made it clear that excuses would not replace accountability. In the end, the judge imposed strict probation, treatment requirements, testing, community service, and a strong warning: take recovery seriously, or risk facing much harsher consequences in the future.
What began as a routine drive on Interstate 94 quickly turned into a courtroom battle. Police officer King testified that he observed Crystal Rowan repeatedly drifting out of her lane and nearly exiting the freeway where no exit existed. Rowan argued that she was distracted, emotional, and unsure whether police lights were meant for her. Dashcam footage was played in court as both sides debated what really happened that night. After carefully reviewing the video and hearing testimony, the judge ruled that the officer had probable cause to make the traffic stop. The case then moved forward toward sentencing. What was supposed to be a dream wedding turned into a courtroom dispute. A couple claimed they paid more than $5,000 for wedding photography and video services, but said the final results failed to meet expectations. In court, both sides presented very different versions of what happened on the wedding day. The plaintiff argued that important moments were missed and promises were not fulfilled, while the company defended its work. As tensions rose, the judge focused on one thing: evidence. The hearing became a battle over contracts, expectations, and accountability, as both sides fought to prove who was responsible.